Sir, court officer. Court officer, sir.
ಹೇಳಿ ಸರ್. ಹೇಳಿ.
ಅಡ್ಜೋರ್ಮೆಂಟ್ಸ್ ಕೇಳಬೇಕಾ?
ಪೇಜ್ ವೈಸ್ ಕೇಳಿ. ಪೇಜ್ ವೈಸ್ ಕರೀತಾರೆ.
Page wise.
ಕೇಳಿ.
Okay.
ಹಾ.
Okay.
ಸರ್ ಆರೋಪಿ IPR ನಮಗೆ ಬರುತ್ತೆ.
IPR ಇಲ್ಲ.
IPR
ಸರ್ ನಾಯಕ್ ಸರ್ ನಾಯಕ್ ಅವ್ರೆ
ಹೇಳಿ ಸರ್.
ಸರ್ ನಿನ್ನೆ ಒಂದು RFA ಹೇಳಿದ್ರಲ್ಲ,
ಹಾ.
518 ಅದ್ರ ಮೇಲೆ ಒಂದು RFA ಇದೆ ಅಂತ,
ಅದೇ
ನಂಬರ್ ಕೇಳ್ತಾ ಇದ್ರು ಸರ್ ಸಾಹೇಬ್ರು.
753 ಸರ್. ಯಾವ್ದು ಅದ್ರ ಮೇಲೆ ಸರ್?
ಅದ್ರ ಮೇಲೆ ಇರೋಂತ RFA ಸರ್.
ಇಲ್ಲ ಸರ್, ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಬೇರೆ ಲಾಯರ್ ಅದು.
ಹೌದಾ? ಇಲ್ಲಿ ಹುಡುಕಿದ್ವಿ ಸಿಗ್ತಾ ಇಲ್ಲ.
ಅದೇ ಬೇರೆ ಲಾಯರ್ ಸರ್, ನನಗ್ ಗೊತ್ತಿಲ್ಲ ಅದು.
ಸರಿ ಸರ್, ಆಯ್ತು.
ಆಯ್ತು ಆಯ್ತು ಸರ್.
ಒಂದು ವಾರ ಏನಕ್ಕೆ ಸರ್? ಇನ್ನರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಬರಲ್ಲ, ಅಡ್ಮಿಷನ್ ಇರ್ಬೋದು. ಆಯ್ತು, ಒಂದು ವಾರ. ಗೊತ್ತಿಲ್ಲ ಅಂತಾರಲ್ಲಪ್ಪ ಅವರು. ಇವೆಲ್ಲ ಸರಿ ಇದಾವ? ವಾರದಲ್ಲಿ ಬರುತ್ತೆ. ಅದಾದ್ಮೇಲೆ 25 ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ 25 ಆಯ್ತಾ? 1230 connected, 1231 connected. 731 connected. ಮೂರಿವೆ ಕನೆಕ್ಟೆಡ್. ನೆಕ್ಸ್ಟ್ ಲಾಸ್ಟ್ ಕೇಸು 1572. ಆತರ ಮಿಲಿಂದ ದಂಗೆ ಅಂತ.
New mothers. After mother. If I what was day mother, day of the money shoot mother, now the execution is to buy it put it on 23rd. There is some urgency.
No, that, what is that RFA number?
RFA number 896 to 2023 month.
23.
23.
Why that interim order has not obtained when that admission at the time of admission?
Admission, there is condition put matter, we are ready to deposit the amount. But now the execution is quoted on 23rd.
Lord, it's a question matter, my lords. Responsible trying to change the nature of
Yes.
property, my lords.
First
Kindly have it tomorrow, my lords.
Page number one, serial number 1 to 9. Page number 2, serial number 10 to 18. Page number 3, serial number 19 to 21. Page number 4, serial number 22 and 23. Page number 5, serial number 24 to 26.
Serial number 24, my lord. Great for which.
We are Vishwanath.
For appellate.
Jayalalitha.
Yes.
Big time
Why?
taking the steps.
Wait, there is unclaimed service, we'll see. And the matter is raised.
Page number 6, serial number 27 to 30. Page number 7, serial number 31 to 33.
Yes. Yes, week's time is granted to do the needful.
Page number 8, serial number 34 to 37.
Serial number 34, my lord.
34, Dinesh Rao N.
1 week time will be granted.
On filing of the proof of valuation filed by the trial court at the request of counsel for the appellant. Is this matter of 2 weeks? Yes.
Page number 9, serial number 38 to 40. Page number 10, serial number 41 to 44. Bill Basappa.
Non-payment of court fee as at the request of counsel for the appellant. Is this matter of 2 weeks?
Page number 11, serial number 45 and 46. Page number 12, page number 30, serial number 47 to 49. Page number 40, serial number 50 to 53. Page number 15, serial number 54 to 61.
Yes.
I'm for the petitioner, my lord, serial number 57. I have informed the other side, the advocate as well. Due to my government
56. At the request of counsel for the appellant, leave this matter of 2 weeks. 57, yes. Yes,
I'm on bed rest, my lord.
yes, at the request of
57, my
counsel
lords. I'm a petitioner.
for- at the re-
Pardon, my lords.
No, we Indian stay ಆಗಿದೆಯಾ? Yes, at the request of counsel for the appellant, leave this matter
My lords, 57.
5th February. Yes. Yes.
Page number 16,
Much obliged.
page number 17, serial number 62. Page number
64,
18, serial
with kind permission, your lord, 64 to 66.
Hmm.
Kindly maybe call along with RFA 753, your lords.
ಯಾವ್ದು ನೆನ್ನೆ ಪೋಸ್ಟ್ ಆಗಿತ್ತಲ್ಲ ಅದ?
ಹೌದು ಸ್ವಾಮಿ, ಅದರ ಜೊತೆಗೆ ಕಾಲ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪೋಸ್ಟ್ ಆಗಿದೆ.
Yes. 64, 65, 66. All this matter along with that so and so ನೆನ್ನೆ ಬಿಡುತ್ತಲ್ಲ.
753.
Yes, next week. Yes.
Please.
Page number 18, serial number 53. Y.K. Narayan Sharma, connected matter.
Yes, you are appearing for?
Here for the respondent number 3.
Yes. You are appearing for which respondent, Mr.? Yes, at the request of counsel for respondent number 2. Please this matter next week.
Page number 19, serial number 67 to 73.
Serial number 73, my lord.
Hmm.
I request for 2 weeks time. And for the appellant,
Ramesh, Krishna Swamy.
The request of counsel for the appellant, please this matter next week. Huh?
K. Chandrachud.
Yes, at the request of counsel for the appellant, please this matter of 2 weeks.
69, my lord. Still have after 2 weeks, my lord. Settlement ನಡೀತಾ ಇದೆ.
69, Krishna
69 at the request
I'm
of
for the appellant.
notice, please this matter of 2 weeks. You are appearing for?
Apajirao Nandre.
Yes, why all that matters? So everybody is taking time. 2016 matter. Yes, at the request of counsel for the appellant, please this matter next week.
Of the appellant, my lord.
Hmm.
G. Manjunatha K. Srinivasa.
The request of counsel for the appellant next week.
Page number 20, serial number 74 to 75, 74 and 75. Kumar B.
The request of counsel for the appellant. This matter on 12th February. Interim order granted earlier is extended till next date of hearing.
Serial number 74.
Hmm.
Inform the
Serial is not keeping. Each time.
What is that name?
Every for the respondent.
Yes. Yes, not well, is saying. At the request of counsel for the appellant, please this matter. Y'all are taking time. I don't know why that. 21st February. ಅಲ್ಲ ಅವ್ರೇನು 3 weeks ಅಂತ ಅಂದ್ರೆ then 14th February. Yes.
Swami Iyengar.
Yes. At the request of counsel for the appellant next week. Yes.
Number 1 for dismissal, Manjunatha for appellant.
Also,
One time office objection. Serial number 2, Chandrasekhar P.
2 weeks at the request.
Serial number 3, Raghu KK. Serial number 3, Raghu KK.
Also,
Serial number 4, Shamanya Slope.
Yes, I request the notice because there's a delay, Manad, and I'll comply the office objection.
what is the top subject?
Artisan rule 11 only plaint was rejected. I have produced the documents pertaining to plaint, the return statement, because Artisan rule 11 only annexures ಎಲ್ಲ ಹಾಕಿದ್ದೀವಿ, but by mistake annexure ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Separate memo ಮಾಡಿ.
Actual number of delays, page number 65 to be removed in that appeal memo.
And remove Manad.
Annexure to be removed in that appeal memo. Why?
No, we can place it after the annexure appeal papers as a separate list. Because when Artisan rule 11 ನಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು plaint. ಅದನ್ನ ತೋರಿಸಬೇಕಾಗತ್ತೆ by arguing the matter.
No, full cost title to be stated in the IA 1 of 2024.
2 weeks ಎಲ್ಲ ಮಾಡ್ಬೋದು.
Pages from 63 to 69 to be removed in that. What is that 63 to 90?
Annexures from a plaint, return statement, documents ಏನೇನ್ ಮಾಡಿದ್ವಿ. Evidence stage ಅಲ್ಲಿ, cross examination stage ಅಲ್ಲಿ Artisan rule 11
Of annexures to be removed in that appeal memo. Detailed memo for valuations to be stated in that appeal memo. What is that?
Artisan rule 11 ನಲ್ಲಿ valuation.
No. Appeal valuation has to be suit valuation has to be said, Mr.
Mention for the purpose of appeal memos within single judge ಮುಂದೆನೆ ಬರುತ್ತೆ ಅದು.
What is that valuation? We have to be stated in that appeal memo. Yes. Where is that? What is that valuation before the trial court?
But in para 7 it is mentioned, Manad,
No, there should be an evaluation.
for the
paragraph
purpose
in
of
that appeal memo.
jurisdiction.
Yes.
I understand.
Yes, you do it, pass or tomorrow. Then only notice.
ನಾಳೆ.
Yes. Is this matter Monday?
Monday.
Yes.
One time office
2 days time is granted to comply the top substance.
One time office objection. Serial number 5, Sri R. Deshpande.
Your lordship's week's time may be granted to comply with the office objection. Second set has to be filed.
Weeks
I agree with
time is granted at the request.
Serial number 6, P. Raju.
Raju.
Serial number 6, P.
Artisan food ಹಾಕ್ಬೇಕಾದ್ರೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಇಲ್ದಾನೆ ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಕ್ಲೈಂಟ್ ಶೇರ್ 200 rupees ಅಂತ ಹೇಳಿ ತಗೊಂಡಿದ್ದಾರೆ. ಆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಕೇಳ್ತಾರೆ ನಾವು ತಗೊಂಡಿದ್ದಾರೆ. ಕ್ಲೈಂಟ್ ಪೆಟಿಷನ್ ಮಾಡಲಿಲ್ಲ. ಕೆಳಗಡೆ ದೇವಸ್ಥಾನ 2 ಇದೆ ಸರ್. ಕೆಳಗಡೆ ಅದರ ಮೇಲೆ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಪಾರ್ಟಿಷನ್ 3 ಭಾಗ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
No, they are asking what is the value of the property.
Market value.
That is what they have to be produced. Yes. To find out the jurisdiction of the court. 2 weeks time is granted to file an at the request. 2 weeks time is granted.
Number 7, then today number appellate. Serial number 7,
Also,
fourth time office objection. Serial number 8, Shravan Madhav KP.
Weeks time may be granted, but the fees needs to be paid.
the request 2 weeks time is granted.
Serial number 8, Milan Sebastian for appellant, Bhargav G.
Weeks time is granted at the request.
Serial number 10, Basavaraj Bedavangala for appellant, Rajani Sisriam.
And I have already filed it. If the memo is not in the file, I am filing.
Karnataka Council for the appellant has filed a memo dated 18/1/2024 seeking leave of this court to filed in a memo for dismissal of the appeal as not pressed. Memo is taken on record. The above appeal is dismissed as not pressed.
Number.
Yes, week's time is limited.
Objection 5 to 10 matter, serial number 12, Srinivasa Reddy RV.
Pass
Serial
over.
number 12. Serial number 13, Wendy Vasant for appellant.
Pass
Serial
over.
number 13, Wendy Vasant.
Pass over.
Serial number 14, Adish Kumar MS for appellant.
At the request, 2 weeks.
Serial number 15, Sampathani Chetty. for
My lords, I'm
appellant.
appearing for appellant in this case, my lords. 2 days may be granted, my lords. Will comply with the office objections.
Today's time is granted to comply office objection at the request.
6th time office objection, serial number 16, Rajesh for appeal for appellant.
Comparing to the appellant, my lords, 2 days time may be granted, I think. Petition value.
As a finally, 2 days time is granted at the request to comply that office objection.
For order, serial number 7, Vinod Reddy for appellant, India Mughal.
Is to be taken in respect of R1, R3, R5 postal Sarah as unclaimed. ಎಲ್ಲರೂ unclaimed. Okay. Yes, Mr.
R1, R3 and R5. As intimations. Thickness of it.
ಇದನ್ನು ಮಾಡಿದ್ಯಾ? ನಾನು ನೋಡ್ತೀನಿ. ಅಲ್ಲಮ್ಮ, R5, R3. The unclaimed, Gopala Krishna Reddy. Ramakrishnappa. Yes. Our notice issued to that respondent number 1, 3, and 5. Written with postal Shara as unclaimed. Then service of notice to R1, R3, and R5 is held sufficient. ಏನಾಗಿದೆ ಅಪೀಲ್? ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ? What is this matter, Mr.?
Admission.
Is there any delay? In time, delay. Delay, ಇಲ್ಲ ಸರ್. ಅಡ್ಮಿಟ್ ಆಗಿದೆ. PCR ಎಲ್ಲ ತರಿಸಿ. ಇಲ್ಲ ಸರ್, ನೋಟಿಸ್ ಅಷ್ಟೇ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಸೆಕ್ಯೂರ್ ಆಲ್ಸೋ. Yes, for this matter.
Number 18, Rangaramudi for appellant, Narayan S.
Week's time is granted to do the needful.
Connected matter, serial number 19, Vishnu Egade for appellant, P. Nataraju.
The respondent number 2, the defendant number 3.
Hmm.
In the trial court method, they are not contested.
What is that? How they served? Placed ex parte.
Placed ex parte.
ಯಾರ್ಯಾರಿಗೆ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್
5 and 6.
ಆಬ್ಸೆಂಟ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
Contesting respondents.
Huh?
Contesting respondents.
You are the client.
Yes.
You are suit for?
Injunction has been declared.
You are that defendant number 1 and 2. Why you have made all other defendants sit there? The plaintiff is hereby decreed with the cost. Hereby directed the defendants or our ಮೇಲೂ ಆಗಿದೆ.
Next time.
Second time either. The net counsel for the appellant prays weeks time to do the needful. Yes.
Number 20, K. Subbareddy for appellant.
Sir, I am permitted to carry out the amendment because of the day.
Yes. 2 days time is granted to do the needful. Yes.
Number 21, D. Shivakumar for appellant.
Sir, 1 week's time in order
Yes.
to be able to attend.
Weeks time is granted to do the needful.
Number 22, Amaresh Sen for appellant.
Therefore, 2 weeks time.
To be taken for treatment.
No more than 5.
Yes, 2 weeks time is granted to do the needful.
Number 23, Babu for appellant. B. Channakeshava.
Unclaimed today. Or to A, B, C. ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್
ಹಾ ಸರ್.
5C1 for all places. Realize application. Five, sir. R2. R2, A and B. R2, A and B are residing at so and so. Then ಎಲ್ಲರಿಗೂ ಸರ್ ಒಂದೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. R5. 5.C1 B ಏನ್ರಿದೆ? Respondent number 2 died on so and so, LR so and so. LR of the respondent number 2A, Muniraju, 2B, 2A, B are residing so and so. 5C1 ಅಂತಾರೆ, 5C2 ಅಂತಾರೆ. 5C ಅಂತಾನಲ್ಲ ಆಗ್ತದೆ. Notice issued on IA number 4 of 20. Every year. 21. On IA number 4 of not 21. Notice issued to that LRs of respondent number 2 on IA number 4 of 2021. Notice written in respect of R2A and B as unclaimed, postal Chara as unclaimed in service of notice to R2A and B on IA number 4 of 2021 is held sufficient. Yes, furnishing a PF issue notice to R5C1 and R3 again. R3 unclaimed. C1 and 2 issue notice. Pay process issue notice to R5C1 and 2. A notice issued to that respondent number 3 is written with postal Chara unclaimed in service of notice to R3 is held sufficient. Cover written with postal Sarah. R1 and R5B. R1, R5B. Week's time is granted to pay the process issue notice to R1, R5, C, 1 and 2, and B. Yes. Yes, 4 weeks time is granted to file a paper book.
Number 24, we are Raghunath for appellant, proceeding Jagannatha.
R5 and R7 insufficient.
Finishing of cover issue notice to third time. Postal sheriff first. R3E is unclaimed. R3E ಏನು R3 ಸತ್ತೋಗಿದ್ದಾರ? ಸೆಕೆಂಡ್ ಟೈಮ್ R3E ಇನ್ಕಂಪ್ಲೀಟ್ ಅಡ್ರೆಸ್ ಅಂತಾರೆ ಮತ್ತೆ
ಅಷ್ಟು ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆ. ಆಮೇಲೆ ಇನ್ಕಂಪ್ಲೀಟ್ ಅಡ್ರೆಸ್ ಇನ್ನೊಂದ್ಸಲ ತಗೊಂಡ್ರು ಅವಾಗ ಇನ್ಕಂಪ್ಲೀಟ್ ಅಡ್ರೆಸ್ ಅಂತ ವಾಪಸ್
ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದ ಮೇಲೆ ಅದು ಹೆಂಗೆ
ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರು ಕಳ್ಸಿದ್ರು.
ಎಸ್ ಯಾರದ R3 ನೋಟಿಸ್ ಆಯ್ತು, ಇನ್ನೊಂದ್ಸರಿ ನೋಟಿಸ್ ತಗೊಂಡು ಎಸ್ ವೀಕ್ಸ್ ಟೈಮ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್. Yes.
Maybe dispensed.
Why?
But the other side is not represented. But so many times matter has been listed.
Hmm.
Respondents are not appearing. And when it's the suit is only, I mean, this.
ಯಾರು ಮುನಿರಾಜು ಫಾರ್ R1 to R5 ಇದಾರಲ್ಲ?
They are not representing.
Huh?
So many times when the matter has been listed. But they are not representing.
No, this is your appeal. Why do you worry about that other side?
That's even before the trial court also, but they are not representing.
No, ಇಲ್ಲಿ ನಾಗರಾಜು ಅಡ್ವೊಕೇಟ್ ಇದಾರಲ್ಲ, ಚಾಲು ಮುನಿರಾಜು
But they are not representing.
ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದು ನೀವ್ ಯಾಕೆ ತಲೆ ಕೆಡ್ಸ್ಕೊಂತೀರಾ? ಡೋಂಟ್ ಸೇ ದಟ್.
Sir, consent.
Huh?
It's for declaration. This is only on the ground that partition deed has not been put. Only on the short point.
Yes. ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ಯಾ?
Admitted.
Yes. ಮೆಮೊ ಕೊಡಿ. Cabinet Council for the appellant has filed a memo. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ? Seeking dispensation of paper book. Memo is taken on record. For the present, the filing of paper book is dispensed. Post this matter for hearing. 2nd week of February. 1st week of February. Yes.
Number 26, Kishore B.K. Number 26, Kishore B.K.
On complaints with office of the first time. Password.
Number 27, Suraj Sampath for appellant, Vivek Kulla.
Scrutiny branch for 4th time. An office objection.
ಮೂರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿದೆ.
ಆಯ್ತು ರೀ, 2019 ಇಂದ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ಕೊಂಡು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. In the COVID period, court has issued a notice. Office objection is not compliant. How that, Mr.? 2019 matter office objection complaint ಮಾಡಿದ್ರೆ ಸರ್ವಿಸ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಅಂತ ಅಂದ್ರೆ yes. Non-compliance of the office objection raised by the scrutiny for 4th time. When will you comply, Mr.? Yes, we'll have it on next week. You by the time you comply that office objection first, Mr. Please this matter. Yes, that will see you comply that office objection, Mr. Otherwise, you are not entitled for issuing the notice at all. Without valuation slip, tomorrow if he comes to know that it is not maintainable before this court, 5 years it is pending before this court it has. Yes. Leave this matter on 24. In the meantime, appellant is directed to comply the top subjects.
Number 58, Ragulaman, 14%. Pradeep Naik case for appellant, V. Anand.
Non-filing of the form A and B 14% trying to permit him to appear first. Yes. Yes, at the request of counsel, at the request of the 14%, please this matter after 3 weeks.
3 weeks.
Any date you want?
Date?
26th February. Yes.
It did not take extended. Mediation ಕೂಡ paying ಆಗಿತ್ತು. Mediation.
Entry ಮಾಡ ಕೊಟ್ಟಿದ್ದಾರಾ? Register is print the name of the learned. We announce the response with the consent report is referred this matter. Since the matter is referred. What is that matter?
Money suit.
He is the plaintiff or a defendant?
For the plaintiff. Decree ಆಗಿದೆ.
ಏನಕ್ಕೆ? What is the transaction?
ಇಲ್ಲಿ ಪ್ಲಾಟ್ ಖರೀದಿ ಮಾಡಿ ಅಮೌಂಟ್ ಪೇ ಮಾಡಿದ್ವಿ, ಪ್ಲಾಟ್ ನಮಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡ್ಲಿಲ್ಲ.
ಅಂದ್ರೆ who is he? Is a developer. ಅಲ್ಲ ನಾನು ಮೆರಿಟ್ ಮೇಲೆ ಇಲ್ಲ. ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅಲ್ಲ ನೀವೇನು ಅವ್ರು ಸ್ವಂತ ಫ್ಲಾಟ್ ಅನ್ನ ಪರ್ಚೇಸ್ ಮಾಡೋದಕ್ಕ ಅಥವಾ ಪರ್ಚೇಸ್ ಮಾಡೋದಕ್ಕೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರು? ನೀವು ಎಷ್ಟು ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟಿದ್ರು? 2.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ರು. No, but you have received 2,50,000.
Between the petitioner and the respondent is there only 1 lakh transaction.
ಬಾಕಿ ಇದೆ? ಎಷ್ಟು 1 ಲಕ್ಷ ರೂಪಾಯಿ ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದೀರಾ? ಈಗ ನಿಮ್ ಲೆಕ್ಕದಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕು? 2,50,000. 1,50,000 ಅವ್ರು ಕಟ್ಟಿದ್ದಾರೆ.
ಡಿಗ್ರಿ ಒಂದ್ಸಲ ಆಗಿದ್ದಾಗ 8 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದು, 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದು. ನಾವಂದ್ರೆ ಇಲ್ಲ 1.5 ಇದೆ ತಗೊಂಡು ಇನ್ನ ಬೇಕು 2,000 ಕೊಡ್ತೀನಿ ನಾವು.
ಆಯ್ತು, ಪ್ರಿನ್ಸಿಪಲ್ ಅಮೌಂಟ್ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ 2,50,000ಗೆ.
ಡಿಗ್ರಿ ಅಮೌಂಟ್
No, case is still pending. Settlement is that it is not attained finality.
ಪಾರ್ಟಿನ ಕರೆಸ್ತೀನಿ.
Any other
Principle, people are violated.
Yeah, this proposal has not put before that mediation. Principal amount ಗೆ ಅಲ್ಲ ಪ್ರಿನ್ಸಿಪಲ್ ಅಮೌಂಟ್ ಕೇಳಲಿಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಅವರು? ಆಯ್ತ್ರಿ, ಮೀಡಿಯೇಷನ್ ಅಂತ ಅಂದ್ರೆ ನೀವು ಅಷ್ಟು ಕೇಳ್ತೀರಾ, ಆಗೋದಿಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ಈಗ ಮಾಡ್ತಾ ಇದ್ದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ವಾಟ್ ಮೀಡಿಯೇಷನ್, ದಟ್ಸ್ ದೇ ಆರ್ ದ ಎಕ್ಸ್ಪರ್ಟ್ಸ್. ದೇ ಹ್ಯಾವ್ ಟು ಸೇ ನೀವು ಅಷ್ಟು ಆಗಲ್ಲ ಅಂದ್ರೆ ಆಯ್ತ್ರಿ ಇದಕ್ಕೆ ಮಾಡ್ತೀರಾ ಅಂತ ಕೇಳ್ಬೇಕು. ಅದನ್ನು ಕೇಳಿಲ್ವಾ ಅವರು ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ? ಕೇಳಿ. ಪರ್ಪಸ್ ಆಫ್ ಸೆಂಡಿಂಗ್ ದ ಮೀಡಿಯೇಷನ್, ವಾಟ್ ಇಸ್ ದಟ್ ಮಿಸ್ಟರ್? ನೀವು 3.5 ಲಕ್ಷ ಕೇಳಿದಾಗ ಆಯ್ತು ಅಟ್ಲೀಸ್ಟ್ ಪ್ರಿನ್ಸಿಪಲ್ ಅಮೌಂಟ್ ಕೊಡ್ತೀರಿ ಅಂತ ಕೇಳಬೇಕು. ಅಲ್ಲಿ ಆಗುತ್ತೋ ಇಲ್ಲ, ಅಲ್ಲಿ ಫೈನಲ್ ಆಯ್ತು, ದೆನ್ ವಿ ಕ್ಯಾನ್ ಡಿಸೈಡ್. ಆಯ್ತು, ಎನಿಹೌ ದಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ದಿಸ್ ಥಿಂಗ್. ಅಲ್ಲ ನೀವು ಕೇಳ್ಕೊ ಬನ್ನಿ, ಎನಿಹೌ ವಿ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ 26. In the meantime, if it is agreed, it's this thing. Otherwise, you will file a proper this thing. We will hear the matter on merit. Entry matter granted earlier is extended till next date of hearing.
Number 29, Shivakumar M. for appellant, G.S. Srikantegonda.
Furnishing of week's time is granted to do the needful. Entry matter granted earlier is extended till next date of hearing.
Number 30, Varmaya for appellant, K.D. Satyanarayana.
7 is not claimed. Other respondent 2.
No such person insufficient to address taken. Yes, for the R7. Notice issued to that respondent number 7. Written with notice.
Not claim. actually.
Written with postal shara, not claimed. In service of notice to R7 is held sufficient. Week time is granted to pay the process issue notice to other respondents. Served respondent. 2 weeks time is granted to file a paper book. 4 weeks to file a paper book. I'm filing a paper book. Ready? File it in that office. Yes, week's time is granted to file a paper book. ಏನ್ ಬರ್ಬೇಕದು? Office is directed to show the name of counsel for the respondent R1 to R1 and R2 properly as Nagaya. Yes. Paper book ಅವರಿಗೆ next week. Yes.
Number 34, number 33, Somashekara KM for appellant, Hiren Michael.
I memo on 23/1/2020. Seeing the death of the appellant in this matter.
Appellant himself is dead. When it is dead?
My lord, he died on 29/7/2021.
21. Sole appellant, huh?
ಹೌದು, sole appellant.
Oh, yeah. Oh, yeah, that's the end. Senate counsel for
R1.
respondent number 1 has filed in a memo enclosing death certificate that sole appellant has died on 29/7/2021. So far, no steps has been taken to bring LRs. Hence, appeal is abated, dismissed as abated.
Number 34, number 35, Satya Narayana Reddy for appellant.
For the appellant in this case, my lords. Already filed a compromise application, my lords, but I could not able to secure all the parties to the court today. It may be 1 week time may be provided, my lords. I will keep all the parties present before the court, my lords.
Which date you want, Mr.?
Any next week, my lords, any date, my lord. On 29th or 30th, my lords.
Twenty-nine.
Please, my lords.
Yes, leave this matter on 29th.
Number 36, Satya Narayana Chelke, case for appellant, Afzal Khan. Number 36.
This matter, my lord, I appear for respondent number 2, my lord. My wakalat has been filed in on 23/6. My name is not shown. R2.
YK Narayan Sharma has been shown as R2.
Oh, anyway, it's all right. He has to take steps. He has to take steps. Appellant.
Week's time, none appear for the appellant. Week's time is granted to do the needful.
Number 37, Amagesh Lemedi for appellant,
Paper books was already dispensed.
But they have to file a paper book. Okay. ಮತ್ತೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಆಗಿದೆ?
Don't know why this
ಲಾಸ್ಟ್ ಅಲ್ಲಿ ನೋಡಿಲ್ಲ.
What is this matter?
Suit and counter suit filed by the appellant hearing and the KV responding to one.
For what suit for?
A portion of a property which is standing in my name. A shop premises which was constructed was given in favor of the present appellant, who is other than the brother-in-law of the KV respondent one. But he claims that he got it through a partition, but without making any other efforts. Lord, and this is the exclusive property of the respondent number 1. So by taking into consideration the point of law as well, the trial court has denied judgment, has declared the suit filed by me, and the suit filed by respondent number 1 is dismissed.
That he has filed.
Yeah, two files, appeals are filed. When admitting the matter, Lord, this court has fixed a rent of 3,500 per month, which is to be deposited before this court. Lord, I have filed application for withdrawal of the said amount. Lord, the policy is only narrow.
No, that your application is not posted.
It is listed, my Lord.
Where
IA
is
number 1 of 23 for permission. Corrected matter ಇದೆಯಲ್ಲ ಅದು 320 ಇದೆಯಲ್ಲ ಅದು ಆ appeal ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
IA 4 of for preparation of paper book.
ಅದು ಫಸ್ಟ್ ಔಟ್ ಫೈಲ್ ಮಾಡಿದ್ದು.
Not received since so and so. IA permission to admit.
4 of 22
Permission
that becomes
admitted.
insignificant.
IA?
IA 4 of 22 filed by the appellant seeking dispensation.
In the IA 1 of 2023.
22 ನಲ್ಲಿ 4 of 22 ನಮ್ದು 1 of 23
for permission.
ಹೌದು. ಏನು ಇವಾಗ ಇನ್ನು ತೋರಿಸೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
Yes. Since this court is already passed an order on 6/12/2022 dispense the filing of paper book. Hence, office is directed to delete the note for non-filing of the paper book. Post this matter for hearing. Yes. Post this matter for hearing in second week of February. Yes.
First week ನಲ್ಲೇ ಸಾಧ್ಯ.
First week. Yes. First week of February.
38 Ravishankar is for appellant. It is Bharat Gowda.
Take paper book.
Yes. Week's time is granted to do the needful.
Number 39 Mubarak Begum is for appellant.
Yes, madam. Non-payment of
It has directed to pay time amount 4 lakhs for that. File a memo along with the execution, but
you are the plaintiff for a defendant.
it's a defendant's appeal, sir.
Defendant appeal. Suit for?
For eviction, the Lord, I was a tenant.
Yes. Defendant is hereby directed to vacate the suit schedule promoters. State plaintiff. Further directed to pay the arrears of rent 20,000 to the plaintiff. Plaintiff is entitled for the means profit damages at the rate of 18 from the date of the suit till the delivery of the suit. So and so. Where is your calculation, memo of calculation?
Your Lordship, I have filed a memo dated 8/12/2023 from the execution petition,
The
certified
payment
copy of the
ejectment, so and so, jurisdiction of the court. Court yard suit is 2,48,650. How much, what the valuation before the trial court?
Lord, valuation statement of
Where is that?
from the my refundable deposit with the plaintiff, that was not calculated.
No, what is that calculation is 2,48,000. 2,48,000.
Damages from the filing of the suit.
Arrears of rent
500 per month, Lord. It was 2,48,000.
is the arrears of rent.
Arrears of rent is 26,650, Lord.
Annual rent value of rupees. Entry ado page valuation slip you explain me, madam. What is that?
Lord, I have produced the along with a memo certified copy of the execution petition, Lord, wherein actual claim amount is 4 lakhs, my lord. Recently, I have deposited 50,000 to the plaintiff.
ಎಲ್ಲಿದೆ?
ಅದು separate memo, my lord. 8/12/2023 ಅಲ್ಲಿ I have filed a memo, my lord.
8.
Last previous hearing date.
Execution petition file, copy of this one. Sir. You have handed over the position.
Now produce the order copy of the execution petition.
Now that you are contesting for what?
My lord, the rent amount, my lord, at the claim of the plaintiff is claiming as 18,500. As per defendant, my lord, there is an agreement, lease cum rental agreement, which was never renewed by the plaintiff.
Advance of rupees 2,25,000, the rent from the date of the suit till date of the degree, 1,70,700. Digital amount, 8,40,000 degree amount.
Yes, my lord. In fact, the actual claim is 4 lakhs, my lord. In the judgment, my lord, my refundable deposit, the judgment is silent about the refundable deposit and the rent I have paid up to date, my lord, during the pendency of the proceedings, my lord.
Now that less amount received with that counter interest rate 6%, 2 lakhs plus. What is that? 3,95,000 has been deducted for what?
So it's a refundable deposit, my lord.
But degree is 8,57,000.
Yes, my lord.
Then you are challenging the degree, you have to pay the court fee for that with interest. Therefore, court has calculated.
Yes.
What is wrong in that? You are challenging entire degree, madam.
Yes.
Now then you have to pay a court fee.
Please, I may be granted.
Yes. 2 weeks time is granted to do the needful. There's 2 weeks time to comply the top secrets.
And the another objection is they have to take steps.
Yes, learned counsel for the appellant has submitted that copy has been served to the caveator. Yes. Submission is taken on record.
Number 41, Ramalingam CH for adoption, Kalyana. 41, Ramalingam.
Non-amendment of cost title and non-filing of the amended cost title. Ready? You amend it.
I have petition alone.
Yes, week's time.
That's
Yes. Learned counsel for the appellant granted week's time to do the needful. Interim order granted earlier is extended till next date of hearing.
Number 42, Sagar Beach for appellant, Nayak Kennar.
Since Nicholas Blood, Leonard Senior was used to say that he is ready to vacate the premises. Party is also here. My prayer is, Lord, in the order of the trial court, 2 months time was granted for vacating. 2008 ನಲ್ಲಿ stay vacate ಮಾಡ್ಲಿಕ್ಕೆ premises vacate ಮಾಡ್ಲಿಕ್ಕೆ
ಆಯ್ತು ಅವರು 5 years ಕೇಳ್ತಾ ಇದಾರೆ.
ಅಯ್ಯೋ ದೇವ್ರೆ,
ಅಲ್ಲ ಹೇಳ್ತೀನಿ ಕೇಳಿ.
ಅಲ್ಲ ಅವ್ರ ಕಾನ್ಶಿಯನ್ಸ್ ಒಪ್ಪುತ್ತಾ ನೋಡಿ. Subject to Lord suffering for 2008 for no reason.
ಅವರು ಕೇಳ್ತಾರೆ ಗವರ್ಮೆಂಟ್ ಲೀಸ್ ತರ 99 years.
ಹೌದೌದು.
Now that give it for 1 year and close it.
ಇಲ್ಲ 1 year. ಅಲ್ಲ ಅವರಿಗೆ ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಇದೆ. ನಾನು really Lord I tried to convince that premises conscience Lord.
The appellant is carrying on service station, engaged more than 100 laborers. He has invested substantial amount.
What is
Even
what is the service station?
service station, lot, that is, Isharam lot vehicles, they come for services.
ಸರ್ವಿಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ 40 ಜನ ಅಂತ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್.
100 ಜನ ಇದ್ದಾರೆ.
ಇಷ್ಟು ದೊಡ್ಡ ಸರ್ವಿಸ್ ಸ್ಟೇಷನ್ ಗೆ ಇಷ್ಟು ದುಡ್ಡು ಮಾಡ್ಕೊಂಡು 2008 ಇಂದ ವೆಕೇಟ್ ಮಾಡ್ದೇನೆ.
No, what is the rent they are paying?
50,000 odd.
ಈಗ 75, as of today 75 ಕೊಡ್ತಾ ಇದೀವಿ. Will pay double the amount.
ಅವ್ರ ಕಾನ್ಶಿಯನ್ಸ್ ಎಷ್ಟು ಹೇಳುತ್ತೆ? 1 ಎಕರೆ ಲ್ಯಾಂಡ್ ಗೆ 50,000. Yes,
What is the rent you are expecting?
no, I am not expecting anything, Lord. I want it for my self use, Lord. I pray that, Lord, at least
No,
some
what
sympathy we should.
he wants to do in that? Whether he wants to give it for an rent or
ಅಲ್ಲ ಮಗನಿಗೆ ಒಂದು ಇಂಡಸ್ಟ್ರಿ ಸೆಟಪ್ ಮಾಡ್ಕೊಡ್ಬೇಕು. Because Lord, he is really on a
no, he don't want to give it for rent or lease.
ಇಲ್ಲ ಮಗನಿಗೆ ನನಗೆ ಸ್ವಂತ ಉಪಯೋಗಕ್ಕೆ ಬೇಕು. 2008 itself, Lord, I have issued the notice. Lordship may see. And what has happened, Lord? ಇವ್ರು ಅದನ್ನ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿ ಆ ಪಕ್ಕದಲ್ಲಿ ನನ್ನ ಸಿಸ್ಟರ್ ಅವ್ರದ್ದು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿ ಅವ್ರಿಗೂ ನನಗೂ ಜಗಳ ತಂದಿಟ್ಟಿದೆ. ಈ ಪುಣ್ಯದ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. ಇಷ್ಟು ದೊಡ್ಡ ಇಂಡಸ್ಟ್ರಿ ಇಟ್ಕೊಂಡು Lord, I am, Lord, really suffering, Lord. Lordship may, Lord, record the terms of compromise, Lord, and Lord may relieve me of this. Lord, I am really not interested in his enhanced rent. I really do not want to, Lord, rent it out to anybody else also.
No,
I want
6 months.
ಇಲ್ಲ ಬೇಡ Lord. ತುಂಬಾ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
They are doing in a business.
ಅಲ್ಲ ಬಿಸ್ನೆಸ್ ಅದ್ರಲ್ಲಿ ಚೆನ್ನಾಗಿ ದುಡ್ಡು ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಅದಕ್ಕೆ ಏನು ಲೈಸೆನ್ಸ್ ಏನಿಲ್ಲ ಅದನ್ನ ನಾನು ಅವ್ರಿಗೆ ಹೇಳೋದಿಲ್ಲ. ಬಿಕಾಸ್ ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಕ್ರಿಯೇಟ್ ಎನಿ ಬಿಟರ್ ಎನ್ವೈರನ್ಮೆಂಟ್. Lord, ಅವ್ರಿಗೆ ಒಳ್ಳೇದಾಗ್ಲಿ. ಇಟ್ ಇಸ್ ನಾಟ್ Lord 6 months ಅಲ್ಲ. ದಯವಿಟ್ಟು ನಾನು 2 ತಿಂಗಳಂತ ಅವಾಗ 2018
may make one request, Lord, you ask, Lord, I will pay the double the rate. Lord, kindly, Lord, grant, Lord, 1.5% without seeking further extension, Lord, we am voluntarily handle it.
ಸರಿನಾ ಅವರೇ ಹೇಳಿ ಇವರಿಗೆ ಹಾಗೆ ಮಾಡಿದ್ರೆ his client, Lord, suffers this kind of thing.
No, he is not giving for a rent.
ನನಗೆ
He
ಬೇಕಾಗಿದೆ.
want his own purpose. If it is for a rent, we can
My
say
son
that
is
instead of
unemployed.
giving to that other.
Yes, Lord.
You can
My son is
continue with it.
unemployed. I want to employ him.
Ultimately, Lord, I am a tenant, Lord, that we can't dispute. My only submission is, Lord, I have to, Lord, survive. That's a different matter. Lord, 1.5 year subject to payment of, Lord, double, not even three times the rents, Lord, I am
I am not ready to collect a single penny rent. Let him, Lord, give an undertaking. ಆ ದುಡ್ಡು ಉಳಿಯುತ್ತೆ ಅವ್ರಿಗೆ. ಒಂದೂವರೆ ಅವ್ರು ಕೊಡೋದು ಬೇಡ.
Yes.
ಕೊಡೋದೇ ಬೇಡ.
No, give it the end of this year, December.
ಅಲ್ಲ ಬೇಡ. ದಯವಿಟ್ಟು 4
ಎಲ್ಲದಕ್ಕೂ ಬೇಡ ಅಂದ್ರೆ
ಅಲ್ಲ ಎಲ್ಲದಕ್ಕೂ ಅಲ್ಲ ಅಲ್ಲ ಇವ್ರ ಕ್ಲೈಂಟ್ ಯಾರು ಬಂದು ಅವ್ರ ತಲೆ ಮೇಲೆ ಕೂತ್ರೆ ಈ ತರ ಮಾಡಿ ಅವರು he is not suffering from all kinds of ailments. His son is unemployed, Lord. Let him, Lord. I appeal to his conscience. Is it correct, Lord? From 2008 he has taken money. ಅದ್ರಲ್ಲಿ ಒಳ್ಳೆ ಇವರು ದುಡ್ಡು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇವ್ರಿಗೆ ಬೇಕಾದಷ್ಟಿದೆ. ಅದು ಸುಮ್ಮನೆ ಹೆರಾಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂಡ್ ನನ್ನ ಸಿಸ್ಟರ್ ಹೋಗಿ ಅಲ್ಲಿ ನನಗೂ ಅವ್ರಿಗೂ ಈಗ ಜಗಳ ತಂದಿಟ್ಟು ನನಗೂ ಅವ್ರಿಗೂ ಜಗಳ ಆಗಿದೆ. ಇವ್ರು ನನ್ನಲ್ಲಿ ಟೆನೆಂಟ್ ಇದ್ದು ಅವ್ರನ್ನ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿ ಅವ್ರಿಗೂ ನನಗೂ ಜಗಳ ತಂದಿದ್ರು. Is it fair, Lord?
Ask him to find out that alternate arrangements will grant some time.
ಅಲ್ಲ ಬೇಡ
6 months.
ಅಲ್ಲ ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿ ತಾವು 4 ತಿಂಗಳು ಮಾಡಿ ಕ್ಲೋಸೇ ಮಾಡಿ
6 months. Let him make an.
One year, Lord, 1 year, Lord, I will not seek any further life.
No, he don't want that any enhanced rent.
Yes.
He want that premises.
Yes.
Now that make him to make an alternate arrangement. 6 months you vacate that, give it that. You give an undertaking that will not make any further litigation. Without any further, this thing he has to make.
ನಾನು ಇಲ್ಲೇ ಕಳಿಸಿದ್ದೀನಿ. ಅಲ್ಲ 6 ತಿಂಗಳು
ನಿಮ್ ಲಾಯರ್ ಇದಾರೆ. But you have engaged your counsel, yes. Yes. Yes.
May make one submission.
No, he is not ready. I will hear that matter on.
Yes, yes, you lost me, can hear the matter, because on merits, Lord, argue the matter, Lord, lost me,
Yes,
can hear the matter.
paper book has.
I thought that in order to put a litigation.
objection ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಲ್ಲ.
ಮಾಡಿದೀವಿ.
What is that office objection?
Office objection complaint
ಮಾಡಿದ್ರೆ ಅದು ಯಾಕೆ ಬರ್ತದೆ?
What is that non-compliance?
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿಗೆ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
No, you file in a paper book.
You lost me, can file a paper.
On admission itself, Lord, I am prepared to convince my lords that there is nothing in this appeal. There is
No,
absolutely
this is an
admits
RFA.
these.
Our regular first appeal, it's right of.
Correct, but I have filed the stay vacating.
I will immediately, Lord, within 2 weeks, Lord, I will file the Lord paper book, Lord, ask me to fix
Yes,
any
you
date, Lord,
fix
will
the
argue.
date and,
ಅಲ್ಲ ಇವರು
Or you file in a paper book by 1 week, will hear that, yes.
I am
What is weeks, 10 days time is granted to?
a week's time. I'll
Yes. What is that office objection?
ಇಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ.
Let us see.
Certified copy of seal.
On that day, submission was made that officer is compliant.
Yes, third, admit. 10 days time is granted to file in a paper book. Read this matter for hearing on 12th February. Get ready on that day. We'll hear that. Whatever the result.
Interim order can be extended.
Interim order granted earlier is extended till next date of hearing.
Number 43 essence, number 44, number
Yes.
Appellants are setting in the same address. In fact, they have filed FTP, and even in the cost title of the FTP, same address is reflected of the parties.
Take an hand summons and serve there. Yes.
I'll take answers to the counsel appearing for the
Yes, week's time to
my lord, sir.
do the needful. In addition, the appellant is permitted to serve a copy on learned counsel appearing for the respondent in the execution petition.
FTP 53.
FD, final degree proceedings.
My lord, sir, seeking stay of FTP. It is posted on 24th.
Now, why that interim order is not granted in the first instance?
Not there is a delay of 1,400 days.
Now that notice has to serve without condoning the delay, you serve it and otherwise taken hand summons and we'll have it next week.
Hand summons.
Yes. Is granted to pay the process, issue notice. In addition, permitted to take out hand summons. Serve an hand summons and move before the
I'll
court.
take notice on counsel for
Counsel appear agli right? It is not in a service under law. Again, then we have to take. We take an hand summons and move before the court. We'll take for admission. Writing PCR. What is this, Mr.?
Right has been rejected. Based on the application filed by the applicant. I saw dispensation notice to the other respondents.
You are the plaintiff.
I am one of them.
Now, who are the other respondents? Suit for?
For declaration.
Suit for declaration.
Declaration. R9 has filed the application under R7. Right has been
Others are the beneficiary under the degree.
Others are their vendors. From others, the R9 has purchased the property. Even before the trial court also they placed the expungement.
Now, by dismissing that your suit, they are the beneficiary under the.
They are not beneficiaries. They are not beneficiaries. R9 is the beneficiary from the other respondent. They sold it to the other R9. Even before the trial court also they placed the expungement plan. R9 has filed up.
Yes.
Data appeal is not executed.
Now you are appearing for. You want to dispense the notice to which respondents?
Already dispensed.
Agidya.
Last occasion it was there.
Wait. Meanwhile, parties are directed not to alienate the income of third party interest suits at next date of hearing. Respondents are reserved liberty to seek a modification, vacation, interim order. Notice to that 1 to 8 dispense with the risk of the appellant issue. Then why it is posted today?
Awaiting
PCR. Yes, let the records come. Yes.
And extend the interim.
Yes. Awaiting PCR. Interim order granted earlier is extended till next date of hearing.
I am appearing for the response.
Steps is concerned on that. Issue notice to the respond number 10 ABCE. Notice steps.
As per the general order dated so IA 1 of condonation of delay of one filing in LR application. R14 is that. Notice agidya?
Notice agidya. R14 and R6 ಇದೆ.
R14 is also dead.
The LR's application in respect of respond
Bringing
number
LRs of deceased. Howda? 1 of 15, 2 of 15, 3 of 15. Alva? 7 of 15 ಏನದು? Filing a bring R6. R6 setting aside. R6 notice ಹೋಗಿದೆಯಲ್ಲ?
notice ಹೋಗಿದೆ. ನೋಟಿಸ್ ಹೋಗಿದೆ ಅವ್ರಿಗೆ.
R6 ಗೂ ಆಗಿದೆಯಾ?
ಹೌದು.
Steps to be taken in respect of unserved so and so. Yes. IA 1 of 2015 is filed for condonation of delay of 186 days in filing LR application to bring LRs of deceased respondent number 14. LR of respondent number 14 is served unrepresented. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 186 days in filing an LR application is condoned. IA 1 of 2015 is allowed. Consequently, 2 of 2015 is allowed. Abatement is set aside. IA 3 of 2015 is allowed. LRs of deceased to respondent number 14 is permitted to come on record. Learned counsel for the appellant is permitted to amend the cost setting. IA 7 of 15 is filed for condonation of delay of 949 days in filing an LR application to bring LRs of deceased R6. LR of deceased R6 is served unrepresented. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 949 days in filing an LR application is condoned. IA 7 of 2015 is allowed. Consequently, 8 of 2015 is allowed. The abatement is set aside. IA 9 of 2015 is allowed. LRs of deceased respondent number 6 is permitted to come on record. Steps to be learned counsel for the appellant is permitted to amend the cost title. Unserved respondent, week's time is granted to pay the process. Issue notice to unserved respondent. Amend madi. Connected.
10:34.
ಇದರಲ್ಲಿ R2 ನಾ ಯಾರಿಗೆ IA
Year 2 of 2022 for filing LRs of the
ಒಂದರಲ್ಲೇ ಎಲ್ಲ ಇದೆ.
respondent number 2 month.
IA 2 of 2022 is filed for condonation of delay of 2486 days in filing an LR application to bring LRs of deceased R2. LRs of deceased R2 is served unrepresented. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 2486 days in filing an LR application is condoned. And abatement is set aside. LRs of deceased respondent number 2 is permitted to come on record.
ಮಾತ್ರ ಸರ್ವಾಗಿಲ್ಲ, ಬಾಕಿಯವರೆಲ್ಲ ಸರ್ವಾಗಿದೆ, ಪೆಂಡಿಂಗ್.
ಯಾವ್ದ್ರಲ್ಲಿ?
R6.
Yes. Steps issue week's time is granted to pay the process. Issue notice to unserved respondent.
560 awaiting service of notice ಇದೆ.
Yes.
ಇಲ್ಲಿ R43 ಗೆ lordship may kindly see R43 ಗೆ not claimed ಅಂತ ಬಂದಿದೆ. It is to be taken into
46.2 ಅಲ್ಲಿ notice issued to the respondent number 43
not claimed,
written with postal shara not claimed in service of notice to R43 is held sufficient. Avoid service of notice to R21, 24, 30 to 34, 38, 40 to 42 and 45. Week's time is granted to pay the process. Issue notice to respondent number 26. Yes.
carry out in the office ಮಾಡಿದ್ರೆ number of LRs are
No, but we have to make it in the top by order. Then you have to file an amended this thing.
amended calculator of filed it in the registry ಮಾಡಿದ್ರೆ, but the amendment is also made in the office ಮಾಡಿದ್ರೆ lot of confusion.
Yes.
Do in that office.
Yes.
Please.
I appear for the respondents 1 to 4, Swami. We had taken time. Your Lordship, the second respondent is having her exam today. So I humbly request to post it on 30th of this month, Swami.
No, that will condone the delay, 40 days. What is that appeal suit for, madam?
I'm a proxy advocate, Your Lordship. The matter is getting settled. Both are, there is settlement going on, Your Lordship.
Oh.
So we will be appearing on 30th. I pray you kindly give a time till 30th.
30th?
30th of this month. Yes, sir.
Yes, sir. The request. Read this matter on 30th. Yes.
Much obliged.
Number 48, Chittappa for appellant Vinod Prasad.
Madam Mila, the application, and I, India 2019, but it is to initiate proceedings under section 344 of CRPC against one Raman. Subsequently, the matter was quoted for final hearing on 30th March 23. The Lordship heard me in part. And during the course of argument, when I sought the rules of the court that the entire survey number is acquired by BDA, the Lordship directed me to obtain a notification from BDA. At that stage, the matter got adjourned.
Okay,
the application of 2019.
That will be considered at the time of hearing. Yes. Yes. IA.
To argue the matter on
IA 2 and 3 of 2019 will be considered
second round of
at the time of final hearing. Please this matter for hearing. Yes.
Number 49, Narasimha for appellant.
Third for respondent number 6 and 7, Shara is received as unclaimed. Take up fresh process for respondent number 4 and 9. And in respect of respondent number 2, my lord, we file
application. Unclaimed. Yes. What do you know? R6, R7. R6. Jingade. Not claim. Return to sender. R7.
file application to bring LR.
Cheshana Rao.
R7.
P. Cheshana Rao. Not claim. Return to sender.
Yes. Notice issued with the respondent number 6 and 7. Written with postal Shara. Claim. In service of notice to R6 and R7 is held sufficient. R2 is dead.
Yes, my lord. File application to bring
Yes. Learned counsel for the appellant prays 2 weeks time to file necessary application to bring LRs of R2. And weeks time is granted to pay the process to issue notice to unserved respondent. Other unserved.
Print list.
You have to give a print list for paper book. Yes. Manjunath, 12th annual, 12 asset. Yes, office is directed to show the name of AC Manjunath for respondent number 12 in the cost list. And leave to the production of additional IA for objection. Yes, Mr.
This man was final hearing. As and when the council, the appellants need it again, they get it, it's posted for orders. Kindly see the dates. My lord, I had heard it. 16, 2023, 27/1/2023, 31/1.
Yes, we'll post for hearing. All that application will be considered along with that.
Sorry, my brother. But there is those market costs in the sense it becomes not workable. They have taken in possession and constructed a house and very recently a house warming ceremony was also. Therefore, in the wake of my leave, for this pre-petition.
Want to
It's too risky on my part to make a submission, my lord to record it.
yes, what is the suit for?
For very injunction,
You are the plaintiff or a defendant?
plaintiff.
One thing, my lord, I asked earnestly before. We spoke of as it is not workable, in the sense not, it has become useful. And liberty may be given to me to file a suit for declaration because I never attempted to question my right under section 24 of the specifically act to seek a definition of my legal character or legal relationship with the land in question. I see problems. So if this observation comes, my lord can dispose.
Yes, liberty to file in accordance with law, if law permits, yes. Learned counsel for. Now you have put up in a construction and all in the.
House warming ceremony.
Yes, learned counsel.
I was not invited.
No, you have created a problem, therefore you don't want to allow you to come inside. Yes.
I was not invited.
Yes. Learned counsel for respondent has submitted that. The respondent is in the possession of the property and he has constructed a residential house and he is residing in the same. Therefore, the appeal at this stage, the appeal will not survive for consideration. Under these circumstances, the above appeal is disposed of, reserving liberty to that appellant to file a comprehensive suit before the competent court in accordance with law, if law permits. All pending applications are disposed of.
Petition and separate possession
Yes,
decreed by the trial court.
yes. What is that, Mr.
They have filed wakalat
Paper Potila? Suit for partition.
partition. ಈಗ ಫೈನಲ್ ಡಿಗ್ರಿ ಹಾಕಿ ಸರ್ವೇಯರ್ ಎಲ್ಲ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ. ಕನ್ಸರ್ನ್ ಡ್ರಾಯಿಂಗ್ ಅಪ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ.
Hello, why? What is the dispute?
Dispute is not property belong to Nagireddy. But he had only one son, Munireddy,
You are also family member.
family member, and 5 daughters. And Munireddy Milord died in the year 1982. And being the only son, the father of the appellant was the sole surviving co-partner. Not the entire property vested with him, as per the then existing law. Now, Lord, after the amendments of 2005, the female heirs have filed the suit. The question would be, when the property, as on the date of death of the propositor, vested with the sole surviving co-partner, can it be subsequently reopened? After the amendment is one question. And
Why it cannot be reopened?
but it already vested with the
Not vested. Since your father is dead, then you are the family member. It has been continued.
Avagandre, as per that law.
See, there is no law which automatically this properties belongs to all surviving children. Since you are a male member, you are continuing that. Now they have a right. They have filed a suit for partition.
Hagenandre, if in a joint family, if there is only one co-partner male member, it will cease to be a co-partner property, and the entire property will vest with the sole surviving co-partner of the as per Hindu law.
Now, in view of the amendment,
Everything is gone. Now that they say that amendment is the female are entitled for the share by birth.
whether they can divest the vested interest in a case where it has existed as a joint family, yes. When it ceases to be a joint family, and whether the law has the effect of divesting the vested interest is one question. But secondly, I have contended item number 17 to 22 are my father's absolute property self-accord because he was employed in Bemel.
Has he given any interstate? Has he given any will or anything in
He purchased the property out of his own income.
And then others are your sisters?
On the aunts.
Your aunts?
Aunts.
Or your father's sisters?
How? Father's
sisters. Huh? I let him give the copy.
Only thing is, they are coming to survey the house of the.
appeal pending ಇದೆ.
ಅಲ್ಲ ಅವಾಗ ಸರ್ವೆ ರೆಪಾರ್ಟ್ ಆಗಲಿಲ್ಲ ನಾವು
appeal ಹಾಕಿರೋದು 19ರಲ್ಲಿ 1 week ನಲ್ಲಿ ಇನ್ನೇನಾಗುತ್ತೆ?
No, you give the copy, we'll have it on Tuesday or the Wednesday. Yes, Wednesday. 30th. Yes.
Partition urgents ಬರೋದು ಸರ್ವೇಯರ್ ಬಂದ.
Let us see. See, you give the copy, then we'll see that. If you have any case, then we'll say that drawing of final degree will be stressed. Yes.
My lords, I appear for the appellant in this matter, my lords. My lord, I seek for 2 weeks accommodation in this matter, my lord.
Why? Jagdish Shiki?
My lord, the property in question, my lord, was mortgaged to the second respondent. There was another RFA pending before court all 2, my lord. The property in question where we had borrowed certain amount, my lord, they have given us a week time to pay back the amount as such. Even
you are the plaintiff or a defendant?
My lord, plaintiff, my lord.
Suit for?
Ejectment.
Recovery of the arrears of the rent.
Please, my lord.
Ejectment and recovery. You are the owner.
Owner, yes, my lord.
What has happened to your suit?
My lord, in that the property in question was mortgaged. As I was a defaulter, my lord, they had initiated proceedings against me for recovery of the amount. And as such, the matter was seized before court hall number 2 today, and they have granted a week's time to deposit the amount. As such, my lord, there is a possibility of settling this matter too. As such, my lord, I seek for a short.
No, that is for that KSFC.
Please, my lord. Even
what about that your tenant?
There is a possibility of settlement, my lord. As such, I seek for an adjournment.
No, that is different. Why your suit for ejectment has been dismissed?
My lord, they say that there is no relationship of a owner and a landlord and a tenant.
That in this case,
true,
even if you succeeded there, that
please.
Is why you can retain that property instead of it is acquired by that KSFC. Now that it is between you and the defendant, you are appearing for whom?
Second respondent CH-11, which has granted on
Yes.
the plaintiff. But the currency of the mortgage, the plaintiff executed an agreement to he has filed a suit for specific performance. That's what is decreed without recognizing the rights of the KSIADC. We are in appeal before the Honorable Division Bench, challenging the judgment and decree of specific performance, contending that our rights should have been recognized by the trial. That matter, today, there is an order has been passed directing the plaintiff hearing to pay the outstanding dues to KSIADC, then only the appeal will be heard.
No, if you pay that amount,
please, my lord,
then this property will goes to purchaser, not for you. You have lost both sides.
For the anterior period, if we establish
No, that you have filed an appeal. Now that that purchaser has not contested that.
He has also filed an appeal. That appeal came to be dismissed for direction of the court. He has asked both ways, but here, if he establishes the dual relationship of landlord and tenant,
yes,
and establishes that he was entitled to rent, then this is considered.
No, but see, if he paid that amount, then you will withdraw that appeal. Suit has been decreed in favor of X. What is his right then?
The date of decree, that person may become owner after execution. This is for an anterior period. This period is anterior period.
No, he can't file a suit for eviction because he is not an
Eviction may not survive, my lords. Insofar as recovery of damages may.
that he can further narrow. Because now that it is for that, he can step into his shoes and come and this thing. He can contest that matter.
Only to the extent of recovery of damages or rent, he can prosecute this.
No, but the thing is, court said that there is no relationship.
It is not true.
Then, yes, Mister. When
My
do you
lord.
want?
Any day, my lord, after 2 weeks, my lord.
Yes, at the request of counsel for the appellant, leave this matter after 2 weeks.
This scheduled on 31st.
After that, you move this matter. That's all. Yes.
Great.
After that, you have no interest in this appeal. Yes. Yes.
Appellant, my lordship. Class action both the parties present and also agreed to perform their part of contract and settle the issue, my lordship. Sir was suggested the appellant hearing.
ನೀವೇ ದುಡ್ಡು ಕೊಡ್ತಾರೆ ಅವರು ಜಮೀನ್ ನೀವೇನೋ ಅವ್ರೇನೋ ಅವ್ರು ಯಾರೋ ತೀರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಬೇಡ ಅಂತ ಅಂದ್ರೆ ವೈ ವಾಟ್ ಇಸ್
Agreed. Both are agreed, my lordship.
ನೋ ಇಸ್
Today, it is posted for the submission of the bank account details, loan amount, my lordship. It is a requisition to the bank manager to settle the matter. It was about to be settled around 24 lakhs, my lordship, at one time settlement. The bank manager forwarded the same to the NRBS to get approval, my lordship. It is around 24 lakhs, my lordship. They have to pay rupees 34 lakhs, my lordship. So it is easily likely to be settled. No issue, my lordship. 1 month time may kind be granted to file the statement, my lordship. After getting it approved from the head office.
Now, what is that settlement you are going to do, Mr. Nagar?
Perform their part of contract.
Balance is the 34 lakhs to 45, 11 lakhs as well.
Remaining amount he has to pay.
Remaining amount, ಅಷ್ಟೇ 5 to 34 lakhs.
Yes, where is that?
Yeah, she is also agreed with.
Now you have to pay that amount to which in
Now I have to receive that amount.
ಎಷ್ಟಿದೆ ಅಂತ amount ಎಷ್ಟು?
ನಾನು statement ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ. ಎಷ್ಟಿದೆ ಬ್ಯಾಂಕ್ ಇದೆ?
Yes, taken the loan.
There is a loan
amount has to be.
ಅದು ಎಷ್ಟಿದೆ?
That you have to be furnished.
Furnished.
When do you want?
1 month time may kind be granted.
1 month agree.
It is sent to the head office, my lord, to get approval.
We'll have it after 2 weeks. Let us see. If there comes, then we'll yes. Please this matter.
Earlier interim order granted earlier may kindly be extended.
Yes. Please this matter after 2 weeks at the request of appellant. Interim order granted earlier is extended till next date of hearing.
Krishna. Number 54.
Yes, Mariappa. What is this, Mr.?
Within 3 months and you pay 14,000 per month.
Yes, none appears. We'll have it after 2 weeks.
It will be because I have taken an undertaking to not to consider the matter.
Not extended. Request of the appellant, leave this matter. There is no extension of interim order. None appear for the appellant, leave this matter 2 weeks.
Narayan Rao for appellant, Vaishali Agde.
Yes. What is this, Mr.?
It is appeal, my lords.
Who is dismissed? Why?
Part of the petition and there is no ready evidence not been proved by the plaintiff.
Then where is the plaintiff?
What is the petition?
4 weeks time is granted to needful. They are appearing regularly.
Second, they sought time to comply with all suggestions.
Now they are complied. None appear for the appellant. Please this matter of 3 weeks.
Number 58, Kiran Viran for appellant. Number 58, Kiran Viran.
Also.
Number 59, Kiran for appellant.
Yes, Mr.
The tenants must appeal. But OS filed for injunction.
Yes.
But on the ground that the defendant's grandmother has sold the property to them. My lord, your lordship may kindly look at this. My lord. This is a suit for bare injunction.
Yes.
Where, my lord, the defendants in the written statements are very clearly said that this was, my lord, they belong to SC/ST and that the land has been granted to them.
Yes.
Granted in favor of the grandmother.
Yes.
And it inures to our benefit.
Yes.
My lord, that she did not have the right to sell this portion of the property. Now, my lord, there is no prayer for declaration. My lord, your lordships are aware, my lord, that the Honorable Supreme Court, where Justice Ravindran, my lord, has very clearly called out in what kinds of matters, what relief has to be claimed. What, my lord, the Honorable Supreme Court says is that if there is a cloud on title, then, my lord, they have to seek for a declaration. So here, my lord, when we specifically dispute the title of the person, no, they should have sought for declaration of the title. Without that, my lord, they can't do it at all, my lord. The suit for bare injunction itself would not be maintainable.
Yes. What is that trial court held that regarding that property comes under PTCL Act?
No, Lord, with regard to that, they have not gone into that.
Yes.
All that, my lord, if your lordship sees, they say, in fact, that
Now that you have sold that property, you are not in the possession.
no, we are, my lord, we are in possession. In fact, they did not even have the benefit of a temporary injunction throughout the entire matter. If your lordship sees, only in the end, your lordship may kindly see the relevant portion of the IA for temporary injunction is disposed of. So, my lord, they did not have the benefit of any interim order. My lord, I am only seeking for stay of the order.
No, that what is that order? Injunction.
Yes, Lord, permanent injunction has been granted.
No, you maintain status quo.
Lord, I am seeking for an interim order, my lord, because the suit itself, without seeking for declaration, my lord, the suit itself is not maintainable. That
now
judgment,
that see,
Lord, here I'll just, my lord, without taking much time, my lord, I'll just read. My lord, what my lord, Honorable Supreme Court has done is, Lord, for prohibiting injunction relating to
that is maybe barred under the law, but there is an admitted fact that they have purchased this property by registered sale deed.
but my lord, purchase.
Now that this is the suit.
My lord, what I'm saying is this. So it becomes all the more necessary for them to, my lord, seek for a declaration. Because, my lord, now, once, my lord, it's very clearly held, my lord, that there is, my lord, that they'll have to seek for, once there is a cloud on the title, I'll just read that.
Yes.
Where a cloud is raised over the plaintiff's title.
No, if you are in the possession, then status quo is in your benefit. What is the problem if you grant a status quo?
In fact, my lord, what has happened is there is no proper identification also of the property also. So, my lord, that should not, my lord, all that I'm saying is, my lord, for a limited period, your lordship may give.
Issue notice. Stay of judgment and degree dated 24th July 2023, passed by 10th Additional City Civil and Session Judge, Bangalore, in OS number 4259 of 2012 till next date of hearing. Yes.
Obliged.
MS for appellant.
Yes.
Declaration. Therefore, dismiss the petition, my lord. LG Ramanna acquired the survey number 125/1 total measuring 2 acres 28 meters. And recently dated 29/10/1958.
When?
29/10/1958.
29/10.
1958.
58.
As per exhibit P2, my lord.
Yes.
The plaintiffs are the legal heirs of the LG Ramanna. The LG Ramanna died on 29/1/1993.
Yes.
The defendant's case is, my lord, on 9/8/1985, LG Ramanna
sold the property in favor of the defendant number 4
Defendant number 4.
through GPA on 9/8/1985,
95.
1985.
Hmm.
The LG Ramanna died on 29/1/1983.
83. 85 he has sold.
Please, madam.
Hmm.
Thereafter, my lord, the defendant number 4 and 3 were the husband and wife, my lord.
Hmm.
The defendant number 4 in turn sold the property to defendant number 2.
Hmm.
That is also GPA dated, my lord, 24/11/1983.
Yes.
Again executed a GPA. On the basis of the GPA, my lord, the second defendant sold the property in favor of the defendant number 1 on 23/11/2010, my lord.
Yes.
The second GPA dated 24/11/93. The sale deed executed on 23/11/2010, my lord. And para 23 of the trial court judgment, my lord.
As the GPA has been produced,
Exhibit D1 and Exhibit D2, my
you
lord.
have the copy of the GPA.
The question is, my case is, my lord, the Exhibit D1 is not proved. The signatures separate by the trial court as per para 23, my lord.
Is it registered?
No,
Para 23.
para 23, my lord.
Yes.
Exhibit D1 is not proved by the defendants, my lord.
Read.
Page number 44, para 23, my lord.
Yes.
Now, the learned counsel for the plaintiffs had given two instances to show that Exhibit D1 was not the document executed by LG Ramanna. Firstly, Exhibit D1 was sent to the handwriting expert to find out whether any of the contents therein are overwritten or written by the erasing any of the existing writing, and also to find out whether countersign at the Exhibit D1A are they signed by very same person. But the handwriting expert gave an opinion stating that countersign found near where the name of the defendant number 4 was typed are not signed by the very same person. And in the affidavit, 10,000 has been overlapped typed, for which the learned counsel contended that the said document is tampered. Thus, they are not genuine. In that event, it is duty of the defendant number 1 and to prove the execution of the Exhibit D1, stating that signatures found in the Exhibit D1, GPA, and affidavit are the signatures of the LG Ramanna. They could have compared the disputed signature with the admitted signatures of LG Ramanna, or they could have examined the attesting witness, or they could have examined the defendant number 4, who is the agent appointed under the Exhibit D1, as it was not done, as the countersign found above the name of the defendant number 4 are not tally to each other. The defendant number 1 and 2 have not resolved to any of the mode available under the Evidence Act to prove the execution of the Exhibit D1. Thus, this court shall draw an adverse inference that as the plaintiff had elicited some serious doubtful circumstances around the Exhibit D1 documents, as though doubtful circumstances have not been removed by the propounder of the document. Thus, this court shall draw an adverse inference on the Exhibit D1 and needs to hold that same is not true. Even the attesting witness also not exhibited.
Then why the court has held that it has been?
Trial court reason, there are 13, the plaintiffs are not produced any document to show they are the only legal heirs of the LG Ramanna.
Where is that finding?
Para 13,
30.
13,
What are the issues framed by the trial court?
Page number 28.
Yes.
Whether plaintiff prove their title over the suit property. Issue number 2, whether the plaintiff prove that the defendants in collusion with each other have encouraged site number 31. Whether the plaintiff prove that the sale deed dated 23/11/2010 executed by second defendant in favor of the first defendant is null and void and not binding. Whether plaintiff prove that they are the entitled for possession. Whether the plaintiff prove cause of action. What we paid is sufficient. Whether the suit is in time. The defendant number 1 and 2 prove that the suit scheduled property was the self-fulfilled property of the LG Ramanna, and he has sold it in favor of the fourth defendant by executing general power of attorney coupled with interest. Whether defendant number 1 and 2 prove that the fourth defendant has executed general power of attorney and sold the property in their favor for valuable consideration as pleaded in para 17 of the return statement.
ಆಯ್ತು ಇಶ್ಯೂ ನಂಬರ್
ಸಪರೇಷನ್ ಮಾಡಿ
85
ಲೇಔಟ್ ಆಗಿತ್ತು.
80 ಏನ್ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ? ಇಶ್ಯೂ ನಂಬರ್ 80 ಏನು ಹೇಳಿಲ್ಲಲ್ಲ.
ಪ್ಲೇಟ್ ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ ರೀ, ಇಶ್ಯೂ ನಂಬರ್ 1 to 6 ವರೆಗೂ ಮಾತ್ರ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ. ವಾಟ್ ಅಬೌಟ್ 8? ವೇರ್ ಇಸ್ ದಟ್ ಇಶ್ಯೂ ನಂಬರ್ 8?
6 ವರ್ಗನೇ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲೂ PW1 ಎಲ್ಲ ರಿವರ್ಸ್ ಬರ್ದಿದ್ದಾರೆ. PW1 ಗುಂಡಪ್ಪ ಇಸ್ ಡಿಫೆಂಡ್.
ಆಯ್ತು, 80 ಎಲ್ಲಿದೆ?
80 ಇಲ್ಲ, ರೆಫರ್ ಮಾಡಿ.
ವಾಟ್ ಇಸ್ ದಿಸ್ ಮೀನ್? ಹ್ಯಾವ್ ದ ಸೆಡ್ ಇಟ್ ಇಸ್
ಪ್ಲೈಂಟಿಫ್ ಎವಿಡೆನ್ಸ್ ನ ಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ನ ಪ್ಲೈಂಟಿಫ್ ಎವಿಡೆನ್ಸ್ ಆಗಿ ತೋರಿಸಿದ್ದಾರೆ. PW1 ಗುಂಡಪ್ಪ ಇಸ್ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಮಿಲಾನ್. ಮುನಿಗಂಗಪ್ಪ ಇಸ್ ಪ್ಲೈಂಟಿಫ್ ನಂಬರ್ 1 PW1. ಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸ್ ನ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ.
ನಿಮ್ ಸೂಟ್ ಏನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರಾ?
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು.
You have any benefit of interim order during the pendency? Notice. Then you take notice.
Please.
Yes, Mr. Show notice.
For matter, case number 1, serial number 1, Manjunatha for appellant.
230.
Serial number 3, Raghu KK. Serial number 7, N. Suresha. Serial number 12, Srinivasa Reddy RV.
Also.
Serial number 30, NB Vasant.
Also.
Serial number 26, Kishore PK.
Also.
Serial number 58, Kiran Vidan for appellant.
Also. Yes.
In hearing matter, serial number 61, Jayashri G. Srinivas for appellant. Connected matter, Kalpana PB, A. Narasimha.
My lord, I'm cross objector, my lord. RFA cross objection 15. My lord, in connected matter 197521 ಅಲ್ಲಿ, I'm a respond number 13, my lord. It may be directed to take notice and maybe directed to
Awaiting service of. See, what is this matter? Who you are plaintiff in the. Why that once it has been disposed of, regular appeal? 2003 in the pending idea. Who is appearing for the appellant in that first matter? Avru yaro? Alla. Plaintiff. Then all are that family members. There is no, he said, cross objector.
I'm a yes.
See, who are the plaintiffs? What are the relationship, madam? Why that, what is the degree passed by the trial court? Suit of the plaintiff is hereby decreed with the cost, partition and separate position. 1/3 share of the plain scheduled to 3 property. Suit plaintiff in respect of the plain scheduled 9 to properties hereby dismissed. Why that suit item 9? Self-acquired properties of defendant number 2. ಅದಕ್ಕೆ ಅವ್ರು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ನೀವ್ ಯಾವ್ದಕ್ಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ? ಶೇರ್ ಕೊಟ್ಟಿಲ್ವಾ? The plaintiff is hereby decreed with the cost. Plaintiff 1/3 ಕೊಟ್ಟಿದ್ದಾರೆ. 1/3 ಅಂದ್ರೆ ಯಾರ್ಯಾರಿಗೆ ಮಾಡಿದಾರೆ ಅದನ್ನ?
Plaintiff, defendant number 1 and defendant number 2, my lord.
Genealogy produce ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು? You come to that judgment and degree. You just explain what is that relationship. Right. Defendant number 1 and 2 are the sons of Uchappa. Defendant number 1 and 2. Defendant number 1 and 2 ಅವರೆಲ್ಲ ಸತ್ತೋಗ್ಬಿಟ್ಟು ಎಲ್ಲಾರ್ಸ್ ಬಂದಿದ್ದಾರೆ. That is not telling you. Where is that genealogy, madam? ಕೊಡ್ರಿ ಅದ್ರ genealogy. Genealogy. ಹಳೆಯದಿದೆ ಸರ್. ಇರೋದು ಅದು ಇದಾಗೋಗುತ್ತೆ ಮೇಡಮ್ ಎಲ್ಲ. ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ಯಾರೋ ಪ್ರಪೋಸಿಟರು? Genealogy of the plaintiff submits that first defendant has been managing the joint family property. The plaintiff as well as defendant number 1 and 2 is given as their under. Plaintiff ಹೆಸರೇನು? ಪೂಜಪ್ಪ.
Defendant number 1.
ಏನ್ ಅವರೆಲ್ಲ ಬ್ರದರ್ಸಾ?
Yes, ma'am.
ಇವ್ರು 3 ಜನ ಬ್ರದರ್ಸ್. Plaintiff defendant number 1 and 2 ಅಲ್ವಾ? 3 ಜನಕ್ಕೆ ಪ್ರಾಪರ್ಟಿ. ಈಗ ಇವ್ರದ್ದು ಸಿಸ್ಟರ್ಸ್ ಇದ್ದಾರಾ? ಯಾರ್ಯಾರು? 3, 4, 5 ಯಾರದು? ಪರ್ಚೇಸರ್ ಬಿಡಿ ಮೇಡಮ್. ಪೂಜಪ್ಪ ನಾಗಪ್ಪ 3 ಜನನು ಸತ್ತೋಗಿದ್ದಾರೆ. ಅವ್ರ ತಂದೆ ಹೆಸರೇನ್ರಿ? ಪೂಜಪ್ಪ ನಾಗಪ್ಪ ಅವ್ರ ತಂದೆ ಹೆಸರೇನ್ರಿ?
Is in paragraph 1 of the judgment, my lord. That
Income
himself,
of his joint family.
defendant number 1 and 2.
Huh?
Himself, that means the plaintiff, defendant number 1 and 2 are the sons of Uchappa.
ಹುಚ್ಚಪ್ಪ ಅಲ್ವಾ? ಹಾ, ನೀವೇನು ಹುಚ್ಚಪ್ಪದ ಮಕ್ಕಳ? ಆಯ್ತ್ರಿ, ನೀವು ಹೆಣ್ಮಕ್ಳು ಮೇಡಮ್, ಯು ಆರ್ ಅಪೇರಿಂಗ್ ಫಾರ್ ಹೌ ಯು ಆರ್ ರಿಲೇಟೆಡ್ ಮೇಡಮ್? ಅನುಪೂರ್ಣ ಯಾರು ಹೆಣ್ಮಕ್ಳು ಮಕ್ಕಳು? You just tell me that Uchappa has how many children?
5.
One and 2, which plaintiff and defendant number 1 and 2 have contributed their earning this to their scheduled property, other immovable properties. Plaintiff submitted defendant number 1 with an mala fide intention to deprive the plaintiff of trying to dispose of the suit scheduled property. ಆಯ್ತ್ರಿ ಹುಚ್ಚಪ್ಪಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು ಅಂತ ಕೊಟ್ರೆ ಆಗೋಯ್ತು ಅಲ್ಲಿಗೆ. ಕೊಡಿ ಅದು ಕೊಡಿ ಅವ್ರು ಕೊಡಿ. ಅಂದ್ರೆ ಅಲ್ಲಿಗೆ ಇಟ್ ಶುಡ್ ಬಿ 1/5. Then plaintiff is entitled 1/5. Then why he has filed an appeal? ಆಯ್ತು ಅದನ್ನ ಕೇಳಕ್ ಹೋಗಿ ಇದ್ರಲ್ಲಿ ಹೋಗುತ್ತಲ್ಲ ಈಗ 1/3 will come to 1/5. ನೀವೇನಕ್ಕೆ ಹಾಕಿದೀರಾ? You are appearing for whom?
I'm for LRs of defendant number 1.
Defendant number 1. You are also one of the son.
Yes, my lord.
ನಿಮ್ದ್ ಕೇಸ್ ಏನು?
My lord,
See, Mr. Now you are saying that all properties are your self-acquired property. Why you have filed an appeal, Mr.? ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಮೇಡಮ್ ನೀವು? ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಇದ್ರ ಜೊತೆಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? Why the court said it is not joint family property? ಯಾರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ? ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1. ಅವ್ರದ್ದು ಕೇಸ್ ಏನು? ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಅಲ್ಲ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ರಿಮೈನಿಂಗ್ ಪ್ರಾಪರ್ಟೀಸ್ ಇಸ್ ancestral self-acquired properties of defendant number 1. Plaintiff proves that first defendant is the karta of the joint family. Whether the plaintiff proves that suit scheduled properties are the joint family properties. Issue number 3. Affirmative ಅಂತ ಮಾಡಿದಾರಲ್ಲ. Whether plaintiff proves that suit scheduled properties are ancestral properties himself on the defendant 4. Affirmative. Issue number 3 ಅಲ್ಲಿ ಅವರು ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 1 is claiming that entire property is self-acquired property. ಅದಕ್ಕೆ ಅವ್ರ ಕ್ಲಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿದೆ. Now that I think it is all properties are joint family properties. Now it has to be divided 1/5 ಅಷ್ಟೇ. 1/5 ಮಾಡಿ our matter can be settled, Mr. Now that law has been ಯಾರಿಗೆ ಸರ್ವಾಗಿಲ್ಲ ಕೊಡಿ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಎಲ್ಲರಿಗೂ ಆಗಿದೆಯಾ? 492 ಅಲ್ಲ ಆಯ್ತು. 1975 ಕೊಡಿ. Then why it is posted for hearing? Why it is notice has not been ordered in the white ಅಂತ ಕೊಡಿ. ಫೈಲ್ ಕೊಡಿ. ಆಯ್ತು. ಈಗ ನಿಮ್ ಕೇಸ್ 1975 ನೀವು ತಾನೆ? Who are that respondents has to be served, who are appearing in the connected matter? Just tell me.
my lord, respondent number 13 is concerned. I'm appearing, my lord. My lord, still I have not, notice has not been ordered. Notice may be ordered.
Wait. Notice order ಆಗಿದೆ. ಡಿಫೆಂಡೆಂಟ್ ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಮೇಡಮ್? ಅಲ್ರಿ 1ರಿಂದ ಹೇಳ್ರಿ. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1, 2, 3 ಆರ್ ದ ಪ್ಲೈಂಟಿಫ್ಸ್. ಯಾರು ಕೌನ್ಸಿಲ್ ಯಾರಿದ್ದಾರೆ? ಅವರಿಗೆ ಡೈರೆಕ್ಟ್ ಆಗಿ ನೋಟಿಸ್ ಮಾಡೋದು. ಎಸ್ ಇದು ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ Jayashree G. Srinivas is directed to take notice for respondent number 1 to 4. What? 12 ಬಿಡಿ 5 ಇಂದ ಬನ್ನಿ 5, 6, 7 ಯಾರು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಯಾರಿದಾರ್ರಿ ಯಾವ್ದಕ್ಕೆ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1A BC ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಮೇಡಮ್ ಪೂಜಪ್ಪ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಯಾರು ಅಪಿಯರ್
1B ಅಶ್ವಥ್ ನಾರಾಯಣ್ ರೆಡ್ಡಿ
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ ಅವರು ಅದನ್ನ ಕೊಡಿ ಅದ್ರಲ್ಲಿ ಹೆಸರು ಯಾರಿದೆ ನೋಡಿ
R1A
ನಾಗರಾಜ್
P ನಾಗರಾಜ್ R1B
ಪೂಜಪ್ಪ ಮುನಿಯಮ್ಮ ನಾಗರಾಜ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅವರಿಗೆ
ಸರ್ 1A ಡೆಡ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸರ್ ಮೇನ್ ಅಪೀಲ್ ಅಲ್ಲಿ 1Bಗೆ ಅಶ್ವಥ್ ನಾರಾಯಣ್ ರೆಡ್ಡಿ C PD ಸುರಾನ್ D to H and 5, 6ಗೆ N ಶ್ರೀರಾಮ್ ರೆಡ್ಡಿ
ಮೇಡಮ್ ಯು ಜಸ್ಟ್ ಸಿ ದಟ್ ಇನ್ ದ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಒಂದು ಚಾರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ವಿಲ್ ಡೈರೆಕ್ಟೆಡ್ ದಮ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ 230 ಅವ್ರು ಯಾರ್ಯಾರಿಗೆ ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅವ್ರ ಹೆಸರು ನೋಡ್ಬಿಟ್ಟು ಒಂದ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಲ್ಲಿಗೆ ಸರ್ವಿಸ್ ಕ್ಯಾನ್ ಬಿ ಕಂಪ್ಲೀಟೆಡ್ ಇನ್ನ KV ನರಸಿಂಹನ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದಾರೆ ಅವ್ದು ಯಾರಕ್ಕೆ ನೀವು ಅಪಿಯರ್ ನಿಮ್ಮಲ್ಲಿ ಯಾರ್ಯಾರಿಗೆ ಸರ್ವಿಸ್ ಎಲ್ಲರಿಗೂ ಆಗಿದ್ಯಾ
ಎಕ್ಸೆಪ್ಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 10
10 ಯಾರಿದ್ದಾರೆ
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 10 ಚಂದ್ರಮ್ಮ
ಚಂದ್ರಮ್ಮಗೆ ಯಾರು ಫೈಂಡ್ ಔಟ್ ಮಾಡಿ 230 then we'll complete that service first Mr. Yes, pass out.
Matter will be Shivakumar.
Which time have we granted?
Why?
Connected is a somewhere. Senior is in arbitration.
ಯಾರು ಶಿವಕುಮಾರ್ the request of counsel for the appellant the counsel for the
There is a connected matter also. Maybe it is along with.
ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಬಂದಿದ್ದಾರೆ ಯಾವ ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ ಹೇಳ್ರಿ ಮತ್ತೆ ಏನು ಗೊತ್ತಿಲ್ಲ ಸುಮ್ನೆ ಬಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ತಿರಲ್ಲ ಎಸ್ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪಲೆಂಟ್ VB ಶಿವಕುಮಾರ್ ಪ್ಲೇಸ್ 2 weeks time leave this matter of 2 weeks.
Number 63 to 70 adjourn. Cell number 71. Yes,
63, my lord, I appear for the appellant. Injunction, the interim order may be extended, my lord. He had moved without information. 63.1. 63.1, the interim order. 13/12/23 order has been passed. Status quo. That may be extended.
Yes. 16.63.1 ನಲ್ಲಿ interim order granted earlier is extended till next date of it.
It's adjourned, my lord. I did not know it. I'm sorry.
Yes, yes.
Cell number 63 to 70 adjourn. Cell number 71. Yes, sir. Mrityunjaya for appellant. Narayan Swami.
Yes, Mrityunjaya.
For their injunction. Respondent in the trial court.
Yes, you are the defendant.
I was the defendant in the trial court. I find and my written statement and contended that the plaintiff had no right over the property in which he is seeking for relief.
On what basis he is claiming a right?
Taking on that and exhibit P1 is the title deed under which he purchases SCZ.
What is that?
The sale deed by the defendant, plaintiff therein. I contended that the property was already acquired by the BDA for formation of Arkavati layout, and the court has also framed an issue stating that whether the plaintiff proves that she is in lawful possession of the property. I also made out and she also admitted that the property is acquired by BDA and this from the same person to whom which belongs, she purchased the property.
even after acquisition. And she says that I am in possession and it is a lawful possession.
What is your claim?
I have stated that the property in which in respect of B schedule property, which is claiming that the road, the BD has not acquired the property and it is left by me in my property in the survey number 21/12 and 21/14. In spite of it, she says that it is the property which belongs to the corporation, BBMP, and no document has been produced before the court to state that this property, this site, this road belongs to the corporation. I have stated that it is my own property. In my own property, I have performed layout and I have allowed my tenants to use that frame. And even the adjacent premise, I have also allowed and permitted them to use the frame road.
No, that your property has been acquired.
No, not at all acquired. Still I having the property, but the plaintiff's property has been acquired under the Gazette publication for permission of layout. It has been admitted also in the cross-examination of the plaintiff.
Where is the finding? What are the issues, Mr.?
Issue. At page 30 of the paper book.
Yeah. Page 30.
Yes, madam.
What are the issues?
Issues. Whether plaintiff proves that she is in lawful possession and enjoyment of such real property, whether plaintiff further proves that they have got interest and access to suit A schedule property through suit B schedule property, that is road portion. Whether plaintiff proves the alleged interference from defendant to suit B schedule property, whether plaintiff is entitled for relief or permanent injunction as paid in the plaintiff or declare. All the issues are in favor of the plaintiff by affirmative.
Yes.
She has not proved that she herself is not the owner of the property. She cannot purchase the property which the property has been acquired already. And moreover, that is a survey number. Survey number land. She says this is a survey number 71. But the sale deed speaks of house list number 71.
Encroaching the road on the eastern side of the plaintiff property by putting up a compound wall by road and ingress egress to the plaintiff to reach that suitable property in any manner. Yes. You read that finding.
She was fighting at 31, page 31, issue number 1 in the affirmative. The
Yes.
reasoning are
Yes,
followed.
you
Page
read-
number.
yes, read issue number 1.
Issue number 1 is whether the plaintiff, I read it. Whether plaintiff proves that she is in lawful possession and enjoyment of such real property.
Read the finding. What is the trial court given finding?
For the above reasons, this court holds that plaintiff has proved that she is in lawful possession and enjoyment.
I try issue number para 8 in the O3. What is the finding?
Reasoning side.
Yes, reasoning para 8 in the O3. Yes.
Yeah, it is the contention of the plaintiff that he has purchased the suit scheduled property bearing site number 2, assessment number 77/1, Batranpura CMC, number 77/1/2, measuring east to west, so and so, consisting of RCC roof residential building and shopping premises situated Amritsar. Under the sale deed, the registered sale deed dated 27/1/2004. From Krishnappa and Kata, it stands in her name. She is paying taxes to it. To produce the substantiate the above contention, plaintiff has produced the original sale deed dated 27/1/2004 as per Exhibit P1. Tax paid receipt P2 to P6. B register extract, that is Kata extract. It's only a temporary without PID number.
You come to the para 11.
Yes. It is the contention of defendant that plaintiff's vendor had no right to sell suit scheduled property to plaintiff because it was acquired by BDA for formation of Parkati level. In this regard, defendants have produced Gazette notification dated 18/6/2014 according property bearing survey number 77/1 standing in the name of Krishnappa and others of Amritsar village was acquired for formation of Parkavati layout. Plaintiff also admitted in her cross-examination para 19 that she was aware about acquisition of BDA by 77/1, survey number 77/1, for formation of Parkavati layout before she purchased suit scheduled property. Defendants have also produced certified copy of RTC pertaining to survey number 77/1
as per exhibit D4 to show that 22 guttas in survey number was standing in the name of Krishnappa, and it was also acquired by BDA for formation of Arkavati extension. However, it is to be noted that here that the suit of plaintiff is not against BDA and not for the relief of declaration that she is the absolute owner of suit property. Her suit is only against dependent with prior to permanent injunction. The issue is also framed on this point is whether plaintiff proves her lawful possession and enjoyment of her suit property. Admittedly, the plaintiff has constructed house and shopping premises in Schedule A property, and she is residing in A schedule property. Whether plaintiff is the absolute owner of schedule property is not, and whether plaintiff's vendor had any right to sell this property to plaintiff or not cannot be decided in this suit, and it is not the scope of the suit. That's what the court comes to the conclusion. When the person who has sold the property himself had no right. It was already acquired by BDA. Under such circumstances, he gives some other number, and not the survey number also, to which he had the right. And he sells the property, and she files a suit against me, the adjacent owner, and seeks for injunction, and that has been granted. That is wrong. She is not in lawful possession. How can she herself the right? It's the right. It is for the proper property itself, not proper, and there is no right over the property to the plaintiff. Under such circumstances, the court.
See, land may be acquired.
Yes.
Position has not taken. That is their contention.
Final notification already over.
I thought that is for the BDA. BDA has to come and issue a notification, notice to evict from them. It is for the BDA for him. Who are you to interfere?
I am not going against that. Nan concern nan jagaದಲ್ಲಿ ಬಿಟ್ಟಿದ್ದೀನಿ. ಅವರು ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅವರು ಇರೋ ವಾಸಕ್ಕೆ ನನ್ನ ಮನೆಗೆ ನಾನು ಕೇಳಲಿಲ್ಲ. ನಾನು ತೊಂದರೆ ಮಾಡೇ ಇಲ್ಲ. ಇವತ್ತು ತೊಂದರೆ ಮಾಡಿಲ್ಲ, ಅವತ್ತು ತೊಂದರೆ ಮಾಡಿಲ್ಲ. In respect of B schedule property which lies to the east of the plaintiff's suit air property, that is the road which is left by me.
Now you come to that finding regarding that B scheduled property. Where is the finding?
Yes.
Yes.
Para 12, para 12. Plaintiff has examined two witnesses, PW 2 and 3, to submit that she is in possession and enjoyment of two scheduled property and A property. PWT is none other than the brother of defendant number 1. PW2 also classified in length para 11 by defendant counsel pertaining to ownership of plaintiff over suit property. There is no specific class examination to PW1 to 3 regarding possession of plaintiff over suit property. In the class examination, DW1 has deposed that he does not know who is in possession of A schedule property, and he does not know plaintiff has constructed house and shopping premises survey number 77/1 of Amrutali village and residing in the said place. He has deposed in para 19 of his class examination that A scheduled property is situated 7 in survey number 77/1. However, in the earlier class examination at para 12, as already stated above, he has deposed that he does not know about construction of house and shopping premises by plaintiff number in survey number 77/1. At para 11, DW1 has deposed that he does not know earlier said survey number 77/1 belonged to one Krishnappa, but further deposed that according to him it belonged to one Uchamma. In the subsequent class examination para 14, DW has deposed that Krishnappa is the son of Uchamma, and he has admitted that he is in his suit. He had also shown the property of Krishnappa as western boundaries to his survey number 21/14. The above evidence of PW1 to 3, DW1 and documents produced by the plaintiff are
This is for A scheduled properties. There is no dispute.
No,
your is on B.
Yes.
Where is that? Then issue number 2 and 3 is for a B. Then you read that reasoning for B.
Yes. At paragraph 17.
Yes.
These issues are considered together as they require common discussion. It is the contention of the plaintiff that they have ingress and egress to suit delay property through suit B scheduled property. Suit B scheduled property is road. To substantiate the above contention, the plaintiff mainly relied on oral evidence of herself and two witnesses and also classification of DW. So this is the oral based on evidence. In the affirmative, in the affidavit evidence of plaintiff specifically deposed that towards east to the suit A scheduled property, 25 feet road is situated, that is suit B scheduled property. In the sale deed as per exhibit P1 produced by plaintiff, the eastern boundary of suit A scheduled property is shown as road. Defendant disputes the existence of this road to suit A scheduled property, but he concedes that there is 15 feet road width and 150 feet length road property is situated. According to defendant, said road is left by him for the usage of himself, his tenants, and also to the public. But according to plaintiff, his road's width is 25 feet and not 15 feet as alleged by the plaintiff, and plaintiffs contended that This road is being developed by BBMP. BWSSB has laid down a pipeline, Kaveri water pipeline, and also drainage pipeline in suitable B scheduled property, and it is not the exclusive property of defendant. That is the content of the plaintiff. In cross-examination of PW1 has deposed that she produced the document to show that BWSSB Bescom has provided electricity in survey number 7/1. Drainages were formed in survey number 77/1. Water tank was constructed to supply water to this layout formed in survey number 77/1. In this regard, plaintiff has produced her electricity bill as per exhibit P7. This is in respect of survey number 77/1, not the Kata number or house list number 77/1.
Yes.
Therefore, the electricity.
No, I am not on that.
Yes.
They are saying that there is a road.
Yes.
Approach road for that A scheduled property. You are claiming that it is exclusively
Yes.
your property. You read that, what is the finding of the tribunal?
A
Now that
scheduled property is has got approach from the northern side. She has got a road on that side.
forget about all these
Yes.
things. Now you have read her case that this is the road of the BBMP. You said it is your property.
Yes.
You read further, what is that reasoning given by that? You stopped there itself.
Yes.
Yes, read that para 22.
Plaintiff has produced exhibit P9, complaint given by the residents of locality to BBMP that they are the owners of properties bearing number 8/377/1 situated towards western side of the road, and Venkatramanappa, defendant, encroached said road portion by putting jelly stones and mud and prevented them from using the road, and when it was brought to the notice of BBMP, its officials stopped Venkatramanappa from putting up construction. On 36/2015, Venkatramanappa again started putting up compound and obstructing people to the road, and hence prayed for taking suitable action against Venkatramanappa and to remove the jelly stones and mud from the road. In this regard, PW2, who is the brother of first defendant, and PW3, one of the residents of Amrutali village, at number 191, have stated in their affidavit evidence of para 4 that survey number 77 for Amrutali village belongs to Krishnappa, who has formed the residential layout by farming roads, rainwater drainages, sanitary and Kaveri water, and Bescom authorities have provided electricity to said layout by installing electric poles. They further stated that in order to provide water to residents of said layout, water tank was being constructed, and since 20 years, water connection to said layout is available and entire area is completely built up. There are more than 25 houses facing eastern side road in the same row. This portion of evidence of PW is not disputed by defendant while cross-examining him. On the other hand, this portion of evidence was further substantiated from his cross-examination. In the cross-examination of PWT has deposed that plaintiff is reaching her property through road left in survey number 21/14. He further admitted that survey number 21/12 or 21/4 are not acquired for formation of road. However, he volunteered that in the road portion left at survey number 21/4, municipality had formed UGD also Kaveri water drain pipelines through said road, and a mini water tank was also put up by municipality, and Bescom had put up electricity poles by inside of said road. Thus, defendant has not disputed that plaintiff is using B scheduled property for ingress and egress to A scheduled property. I have permitted them. Earlier, I have stated that I have permitted my tenants. This road was being formed left by me. I have permitted my tenants, and also I have permitted the other suitable.
Where is that plan which is sanctioned that you have formed that layout and that portion of it has been left for in a road?
Is not no layout for layout.
Then
no layout plan is.
Then where is the document to show that you have left for years tenant as in a road?
Nanದೇ ಇರೋ ಜಾಗ ನಾನು ಬಿಟ್ಕೊಂಡಿದ್ದೀನಿ ಅಂತ ಮನೆ ಕಟ್ಟಿದ್ದೀನಿ ಜಾಗ ಬಿಟ್ಕೊಂಡಿದ್ದೀನಿ.
For that, for formation of the layout and
ಇಲ್ಲ layout formation ಮಾಡಿಲ್ಲ ಅಂತ.
then
ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ, ಮನೆಗಳು ಕಟ್ಟಿದ್ದಾರೆ. It has been assessed by the corporation under A Kata. But whereas the plaintiff, ನಾನು ಇಲ್ಲಿ ಪ್ರಶ್ನೆ ಇರೋದು acquire ಆಗಿದೆ, acquire ಇರೋ land.
ಅವ್ರ land A ಬಿಟ್ಬಿಡ್ರಿ.
The person who has come before the court should pray Allah.
A ಬಿಟ್ಬಿಡಿ. It is for that B.
All right, yes, my lord.
B ಗೆ
Ecological right.
now that B, whether you are saying that it is road is formed by you, it is your property.
Yes. 4 ಗುಂಟಾಸ್ ಇದ್ದೀನಿ ನನ್ನ ಲ್ಯಾಂಡ್, ಅದ್ರೊಳಗೆ ನಾನು ಬಿಟ್ಟಿದ್ದೀನಿ. They without acquiring the land, they farmed the road. I admit that they farmed the road. That is the property which I have left it for the usage of my tenants and also to the others.
Anybody has produced that photographs?
Photographs produce ಮಾಡಿದ್ದಾರೆ ಸರ್. ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
From how many years they are using that property, that road?
15 ನಲ್ಲಿ ಕಟ್ಟಿದೀವಿ ಅಲ್ಲಿ ಮದುವೆ ಮಾಡದೆ ಅಲ್ಲಿ ಇದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರ ಅವರು.
ಅಲ್ಲಲ್ಲ, ನೀವು ಅವರಿಗೂ ಎಲ್ಲ ಪರ್ಮಿಷನ್ 2015 ಇಂದ ಬಿಟ್ಟಿದ್ದೀರಾ?
ಹೌದು.
Yes, Mr. What is the document to show that this has been formed by that BBMP? Yes, he has also admitted that you are using that road. He is saying that it is his property. You are saying that it is a BBMP, electricity pole alla hakidare anta tashna it is not BBMP road adre a land acquire ಮಾಡಿ formation ಮಾಡಿರೋದು ದಾಖಲಾತಿ ಬೇಕಲ್ಲ. And in the map it has been shown that it is a BBMP property. Or if you want to claim there for an easementary right, then it is a different. You have to file a suit for easement. If that somebody's property you are using time immemorial, you can claim for an easementary right. For that, it is in a separate suit for not an injunction. One thing, if that BD has come and vacate your this thing house, either you will not get in a road and house. How that BBMP has left, the BD has left you, the land has been acquired.
Notification ಹಾಕಿದ್ದೀನಿ.
Then BBMP is not a party. The land is acquired. Compensation ಕೊಟ್ಟಿದ್ದಾರಾ? You verify whether they have taken that compensation. We'll ask the BDA to make a BDA as a party and ask them to take an action. Then you will go that property. He has to vacate that premises itself. Then question of road claiming will not arise. Property acquire ಮಾಡಿ compensation ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ it is different. If they taken a compensation, still it is there. It is for the BBMP to issue notice for eviction. You verify.
ನನ್ನ ರಸ್ತೆನಲ್ಲಿ ಅವ್ರು ಅಕ್ವೈರ್ ಮಾಡಿಲ್ಲ, ನನಗೆ ಕಂಪೆನ್ಸೇಷನ್ ಪ್ರಶ್ನೆ ಬರೋದು ನಂದಕ್ಕೆ ಅವ್ರದಕ್ಕೆ ಗೊತ್ತಿಲ್ಲ, ತಿಳ್ಕೊತೀನಿ ಸರ್, ತಿಳ್ಕೊಳ್ತೀನಿ.
ಅವ್ರದ್ದು ಕಂಪನ್ಸೇಷನ್ ನಿಮ್ದಲ್ಲ, ನಿಮ್ದು nobody said that it is an acquired land. ಅವರು ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಆಗಿದೆ ಅಂತ ನೋಟಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ವಾಟ್ ಇಸ್ ದ
further action ಏನು, whether payment has been made to the
made position ತಗೊಂಡಿದೀವಿ ಅಂತ 16 notification ಆಗಿದೆಯಾ? All that you produce next week. That is the only a point. Let us. Then we will ask the BBMP to the BDA to be a party here. Yes. You also verify, Mr. If you are taken that compensation, then what is left?
ನೀವು ವೆಂಡರ್ ಕೃಷ್ಣಪ್ಪ ಅವ್ರು ಇನ್ನೊಂದು ಸರ್ವೆ ನಂಬರ್ ಹಾಕಲ್ಲ, ಯಾವ್ದೋ ಒಂದು ನಂಬರ್.
Ultimately, there is a finding that this is the land which has been acquired. But the trial court said it is for the BDA and plaintiff. You have no role. That is what the finding. Court has not said that this is not acquired. They said it is acquired. Let us see that. Get that further information. Yes. At the request of the parties, leave this matter 2 weeks. Verify if the compensation is 2
weeks.
Yes.
Public.
72 to 75 adjourn.
What do you?
58, then we ask for appellant.
Yes. Yes, Mr.
Suit is for adjournment. The particular property is a residential house.
Yes.
The ownership of the plaintiff is not in dispute. The defendant appears and files a statement. We understand that she is in possession, one as a licensee, and that there was an agreement of sale executed in her favor by the plaintiff. The consideration was 36 lakhs. And she has paid about 9 lakhs as advance. And she also says that the original I had given to the plaintiff, it is not signed, but a photocopy of the agreement of sale is with me. Now, the trial court dismisses my suit, one on the ground I have not proved the jural relationship of landlord and tenant. It is my case that when the husband, according to the defendant's husband was in Hyderabad.
Yes.
Plaintiff is resident in Middle East. He was given to the neighbor
and the terms were finalized. 70,000 was given to me as security deposit. Rent was fixed at 6,500 and lease deed was given to her, which she says, I will take it from my husband and give it. It never came well. Then subsequently, 6 months down the line, 2 deposits are made, 20,000 and 18,000 has been deposited in my account. Then default is made.
Yes.
I issue notice terminating the tenancy and ask the defendant to quit. Defendant admits that she has received that notice, but states that I need not give any reply to that notice. Then in the written statement, this defense is taken. Now, the defense is that there is an agreement of sale. Now, what my stress is, my lord, that when a defendant appears and takes a special plea by way of a defense, then what the law says is, in the event the defendant is unable to prove the special defense, then the case of the plaintiff must be decreed. Now, the burden here was on the defendant because she said that there is an agreement of sale, which I dispute. I have never executed an agreement.
Have you disputed that in that sale deed, the agreement of sale?
Yes, it has never been produced at all in the court.
Only that plea has been taken.
Only plea. And she says 9 lakhs I have paid by way of cash.
Yes.
So this error by the trial court, that in absence of a lease agreement,
yes,
whether I have established the relationship of landlord or tenant,
yes,
there are 3 payments made, 70,000 which is paid as a way of security deposit.
yes,
2 payments have been coming, which is 20,000 and 18,000.
yes.
Why those payments were made, my lord, in absence of the agreement of sale being placed? Best evidence is withheld by the defendant. It should have been produced by her. She
Yes.
does not produce.
Yes.
For last 10 years, they continue to squat on the property. And I have been without rents, nor the property. That's the simple case. The reasons, I can take your lordships through the ownership is not in dispute, my lord.
Yes. Only thing is that trial court said you
Yes.
have executed an agreement.
Agreement of sale.
Where is that finding?
My lord, none of the statements that the defendant says, the trial court takes that into consideration, my lord. It just presses aside. The reasons your lordship will find at para 7 of the judgment, my lord, that is there. Here, 6 issues have been framed.
Yes.
Then, lordship make reasons from para 7 to 22. The relevant para, kindly see, my lord, para 9.
Yes.
First of all, though plaintiff has specifically pleaded that the defendant was a tenant under him in respect of the suit schedule property on a monthly rent of rupees 6,500 from 1/3/2014, and at the time of inception of tenancy, defendant has paid a sum of rupees 70,000 wide checks for a sum of rupees 35,000 each as security deposit, which is refundable on determination of the period of lease without any interest. And in fact, defendant has entered into lease agreement on 1/3/2014 with the plaintiff. And after getting the above lease agreement, plaintiff requested defendant to sign the lease agreement, but defendant took the said lease agreement on the guise of showing it to her husband and never returned it. And in the meanwhile, defendant has neither paid the admitted rents until end of March 2016. Defendant is due to pay arrears of rent of 1,36,000, and thereafter, in spite of issuing legal notice, since defendant neither paid arrears of rent nor vacated the suit schedule property, then plaintiff is constrained to file the above suit for relief of ejectment, arrears of rent and damages is concerned. The same once again do not hold any water because, except pleading the above facts, plaintiff has not at all proved the above material with any cogent material evidence. Now, I have marked exhibit P1 to P7. Sale deed is marked, my lord. Legal notice is marked. Now, kindly see 11, my lord. I'll read, kindly see, my lord, the relevant portion would be 14. 14. The approach of the trial court.
Yes.
And even though defendant has not at all given any reply to the legal notice of exhibit P4, the same is also of no help to the case of the plaintiff, as defendant has specifically taken up a defense that since she has denied jural relationship of landlord and tenant, then question of giving reply to the legal notice at exhibit P4 does not arise at all. Now, my lord, in course of cross-examination, I have asked, have you filed the suit for specific performance? The answer is no.
Yes.
She has not produced the agreement of sale before
No,
the
that
court.
is secondary. First is that you have to prove that.
I have to prove, my lord. Now, it is my case that the leases agreement is not there.
Yes.
But there are 3 payments which are forthcoming. 3 payments are 70,000 to me as security deposit, by way of which fact is admitted. Payments are admitted. There is no dispute with regard to the payments, my lord. If the payments are admitted, and if the defendant is not able to.
There is a judgment.
Huh.
If that
Special
defendant has not denied that plaintiff is the owner of the property.
Yes.
Then he has to prove on what basis he is in the
Absolutely, man.
I think
because in right, my lord, this case on his judgment is there.
Some judgment.
2 judgments are there. The first judgment, Lord, may I just request? Lord, can I just point out to the written statement first? So
Yes.
the defense becomes more
Yes.
accurate. Look, TCR is also available.
Yes.
Now, kindly see the written statement, Lord. Para 5. May I read, my lord?
Yes.
No, para 3, my lord. I'll read para 3 of the written statement.
Yes.
The plaintiff submitted in the present para that the defendant is a tenant under the plaintiff since 1st of March 2014 in respect of the suit schedule property on a monthly rent of rupees 6,500 is payable every month to the plaintiff on or before 7th day of every succeeding month, and defendant shall obtain valid receipt for having paid the same. Defendant would submit that as stated supra, in the resolved jural relationship of owner and tenant, question of paying rent and receiving valid receipt for having paid does not arise. It is relevant to submit here, defendant is not a tenant. However, he has been inducted as a licensee under the strength of sale agreement entered into between plaintiff and defendant on 1st of March 2014. By virtue of the sale agreement of sale, defendant inducted on the date of entry into agreement of sale with the plaintiff. So therefore, my lord, a specific stand is taken by the defendant that I have been put in possession by virtue of the agreement of sale. Now, fact that this photocopy is available with the defendant is forthcoming, my lord, in the defendant's affidavit file in examination in chief.
Yes.
At para 4, examination affidavit, proof affidavit of the defendant, my lord.
No problem.
Sir.
Yes.
Lord, para 4. Lord, let me kindly take the para 4.
Yes.
I state that as there is no jural relationship as owner and tenant, question of paying rent and receiving valid receipt for having paid the same does not arise. It is relevant to state here that I am not a tenant under the plaintiff. However, I was inducted as a licensee under the strength of sale agreement entered into between the plaintiff and myself. By virtue of the sale agreement, I had inducted on the date of entry into agreement of sale with the plaintiff. It is further clarified here that on date of entry into the agreement, the plaintiff have collected the original agreement of sale dated 1/3/2014 on the pretext that he would return the same after obtaining his side witness signature, as there was already witness signed on my side. At that time, plaintiff has handed over photostat copy of the agreement of sale dated 1/3/2014 to me, and by virtue of the above referred agreement of sale, I am in continuous occupation of this.
No, from 2014, she has not demanded for original.
No original. My stand that I take as to why I have not produced the lease, she adopts the same. She's a law graduate. She admits in her cross-examination So now, my lord,
Now, what is she doing in that?
just using it for residential purpose,
Yes,
no rent is paid except 38,000 that I received in 2014, my lord. No rent has been.
What is the law on that point?
Now, law, my lord, your lordship may kindly take the first decision is ILR 1992, Karnataka 1660. Now, page 8 of the memo, this is the case where under 138 proceedings, my lord, if the defense is that money was given to me by virtue of me having executed a contract and it is not a loan, then the court has said it's a special defense that you are taking.
No, that is, no, now that to maintain that petition for ejectment,
I will
you have
rely,
to prove that.
there are other.
Suppose defense has taken that she is residing in your property and admitted that you are owner, whether at that junction it is necessary.
Yes. Now, my lord, three judgment. I just point out to one difference because this is an important judgment, my lord, which para 11.2, my lord, at page 8, in page 8, my lord,
Yes.
just 3 lines.
Yes.
In a case where defendant sets up
Yes.
a special plea, burden is upon him to prove it. And if he fails to prove the special plea, the case of the plaintiff stands. Now, my lord, this is the principle. My lord. The next decision, as what your lordship asked me, my lord, the yes. The next decision, my lord, is AIR 1966 SC 735.
Yes.
Bench of 4 judges, my lord.
Yes.
Now, the relevant para is para 12, my lord.
Yes.
Turning then to the pleadings and evidence in this case, there can be little doubt that defendant knew what he specifically pleading. He had admitted title of the plaintiff in regard to the plot and set up a case as to the manner in which he spent his own money in constructing the house. Plaintiff led evidence about the tenancy set up by him, and defendant led evidence about the agreement on which he relied. Both pleas are clear and specific, and common basis of both pleas was that plaintiff was the owner and defendant was in possession by his permission. In such a case, the relationship between parties would be either that of landlord and tenant or that of an owner of the property and a person put into possession of it by the owner's license. No other alternative is logical or legitimately possible. When parties laid evidence in this case, clearly they were conscious of this position. And so when the High Court came to conclusion that tenancy had not been proved, but the defendant's agreement also had not been established, it clearly followed that the defendant was in possession of the suit schedule property by leave and license of the plaintiff. Once this conclusion was reached, question as to whether relief can be granted to the plaintiff or not was a mere matter of law. And in deciding this point in favor of the plaintiff, it cannot be said that any prejudice has been caused to the defendant. And the next judgment also, my lord, answers that
in this
2009.
we see no reasons to interfere with the degree.
In this case, my lord, what happened?
What has happened to that ultimately?
No, my lord, what happened? Defendant took up a plea that I admit plaintiff is the owner, but I had spent money in construction of the building. I had spent 36,000. So till I recover 36,000, I'm entitled to reside in that house. So the court said, look, whether the relationship is proved or not, fact remains that as a licensee, you are residing in the property. Now here also, in my case, I have read.
What is that final order passed?
Final order is that the defendant should be evicted. Trial court had passed an order, no, allowed it. And High Court also confirmed, but gave, with regard to the rent part of it, there was a difference. Now kindly see the next judgment, which would more aptly apply.
Yes.
Now, next judgment, my lord, which again is 2009, volume 15, SEC 693, my lord.
Yes.
The relevant para is at 17. Now, I have produced my document of title in this case as P6, my lord.
Yes.
Now, 17 says, the landlord in a given case, although may not be able to prove the relationship of landlord and tenant, but in the event he proves his general title, may obtain a degree on the basis thereof. Now, my lord,
My case is very straightforward. I have let out that house, my lord. I have issued notice, no reply to the notice.
No, that she is also admitted that you are that owner. There is
Owner,
no
my lord,
dispute.
but defense should have been at least forthcoming in my reply to the legal notice. If she says that she had an agreement of
No,
sale,
the court has dismissed on the ground that
I have not proved, my lord.
that is
Well,
wrong.
yes, that's all, my lord. But as I said, my lord, if the payments given by
If she has proved that there is an agreement to sale, then it would have been different.
And
Court has not gone into that aspect.
correct. But the payment that defendant has made, court has not asked on what ground these payments were made. If 70,000 is
What-
paid,
That maybe some 2 or 3 transactions you has produced, no lease deed has been produced. Therefore, court might have been doubt that you have failed to prove. But when the defendant has admitted
yes,
that you are a owner, then there is nothing else.
ownership is not.
Yes, if she is admitted and if she is proved her case, then it should have been a different.
Absolutely. That's all.
Yes, who is appearing for other side?
Service ಆದ್ರೂ ಬಂದಿಲ್ಲ.
Will
Last
admit.
last time ಬಂದಿರ್ಲಿಲ್ಲ ಅವ್ರು.
ಅಲ್ಲ ಯಾರಿಗ ಅಪಿಯರ್ ಆಗಿದ್ರಾ?
So again. Now it's been 10 years that we are fighting for this project. No rent, nothing basically.
Now that there is no interim order, anything can be granted in your favor. Matter has to be finally disposed of.
Finally,
Yes.
maybe Lordship feels one more opportunity needs to be given. It can be kept at the same stage.
No, that is the problem. If they are not appeared, law is that if contesting respondent is not appeared, matter has to be admitted. In the hearing, it has to be disposed of. The rule is, she might have been said that, no, I will not appear for admission. I will appear at the hearing. Therefore, the court said, yes, you have to, I will admit it. We'll see if they are not come.
Next
Then,
week happened.
yes. Or you want to take hand summons?
And someone, I will, yes,
Yes.
next week, I'll go and serve by hand.
If they are appeared, we can ask
Yes.
whether if
I
they want to
understand.
settle or we know that what, yes.
What the court says, absolutely.
Yes, yes.
But my only request is, my lord, on a week-to-week basis. If this
Yes, yes,
matter-
we'll see that.
That's all.
Yes. Third. Admit. Respondent is served unrepresented. The net counsel, appellant is permitted to take out hand summons to that respondent. Use this matter on 29th or 30th of January.
Yeah, then 25th half of next week.
Allah, that rule is that 15 days time has to be
15
given.
days, some reasonable time. Yes.
Then we'll have it on 30th.
Yes.
Yes. Use this matter 30th for hearing. Filing of paper book is dispensed.
Paper book was dispensed on the last date.
Itself is dispensed. Why it is not yet admitted? Before admission, it cannot be. Only after admission, we have to be dispensed.
Yes.
Agiri order. Yes, any of that now, yes.
Right.
2:30. No, yes, no, you give that to her. We'll see at 2:30. Yes, put it. Hmm.
Number 1 to 4. Especially the advocate is the one.
1 to 4, huh? Yes. Adrili, Jayashri G. Srinivas is directed to take notice for 1 to 5. 1 to 4. 5, huh? Yes. Ashwath Narayan Reddy is directed to take notice for respondent number 5. 6, Surana. 7 to 11. L. Sriram Reddy is directed to take notice for 7 to 11. Well, KV Narasimhan. Use, yes. So and so is directed to take notice. Respondent number 13. Then you have to take notice in your case. Yes. Issue notice to respondent number 14. 14 and 15. 16 and 17, Sriram Reddy. Ali 14, 15, 18 and 19. Matyaridare notice. ಅಲ್ಲ ನೋಟಿಸ್ ತಗೊಳೋದು ಯಾರ್ಯಾರಿಗಿದೆ ಫಸ್ಟ್ ಹೇಳ್ಬಿಡಿ. 14, 15, 18, 19 ಅಷ್ಟೇ. ಹಾ, ಮತ್ತಿನ್ಯಾರಿಗೆ ನೋಟಿಸ್? ಅಡ್ವೊಕೇಟ್ 20, 21 ಲಕ್ಷ್ಮಮ್ಮ, ಮುನಿಯಮ್ಮ. 20 to 25 SN but then I'll complete. What about that other matter is all service is completed. ಯಾವ್ದ್ರಲ್ಲಿ? ಇದರಲ್ಲಿ 16.1 ಅವ್ರದಲ್ವಾ? ಕ್ರಾಬ್ ಅಲ್ಲಿ ನಿಮ್ದ್ರಲ್ಲಿ ಎಲ್ಲರದಲ್ಲೂ ನೋಟಿಸ್ ಆಗಿದೆ. ನೀವು ಯು ಆರ್ ಟೇಕಿಂಗ್ ನೋಟಿಸ್ ಟು ವಿಚ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿ? So and so is undertake to file wakalat for respondent number 14 and 15. Kaverama and Purushottam. Yes. Office is directed to show her name. Why Purushottam has not made as a party 15? ನೀವು ಎಲ್ಲಾರು ಮಾಡ್ಬೇಕಾದ್ರೆ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಮೇಡ್ ಅನ್ ಲೆಟರ್ ಫೈಲ್ ಯು ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಕಾಮನ್ ರೆಕಾರ್ಡ್. ಅದನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ವಿ ಕ್ಯಾನ್. 1975 ಅಲ್ಲಿ 13 ಹೇಳಿದೀವಲ್ಲ, ಹೇಳಿದ್ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕಂಪ್ಲೀಟೆಡ್. ಅದು ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿದ್ದಾರೆ. ಎಸ್.
Respond number 1F10.
ಇಲ್ಲ, ಅದ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ. ಯಾವ ಕೇಸಲ್ಲಿ ನೀವು ಹೇಳೋದು? ನಿಮ್ ಕ್ರಾಬ್ ಅಲ್ಲ? ಯಾವ್ದ್ರಲ್ಲಿ ನಿಮ್ ಕ್ರಾಬ್ ಅಲ್ಲಿ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 10.
ಅವರು ಶ್ರೀರಾಮ್ ರೆಡ್ಡಿ ಅಂತ ಹೇಳಿ ಫಸ್ಟ್ 492 ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಬಟ್ ಇದ್ರಲ್ಲಿ ಸರ್ವ್ಡ್ ಏನಾಗಿದೆ? 10ಗೆ MFA RFA ಕ್ರಾಬ್ ಅಲ್ಲಿ R10 Sriram Reddy is directed to take notice. L Sriram Reddy is directed to take notice. Aligala service complete cycle. Yes, you have to pay the process for 4. Yes. Yes. Our service ಆಗ್ಬೇಕಲ್ಲ ಅವ್ರದ್ದು. No, without serving their notice, what can I do that? Immediately after service, you move that matter, we'll take that. That notice order agide. Why that notice has been sent? ನೀವು ಅವ್ರ ಕೇಸಲ್ಲಿ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ ಯು ಮೂವ್ ದ ಮ್ಯಾಟರ್, ವಿಲ್ ಟೇಕ್ ದಟ್. ವೈಟ್ ಸರ್ವಿಸ್ ಅಂತ ಬಂದಿದೆ. ವೈಟ್ ಸರ್ವಿಸ್. ಎಸ್. ಅಲ್ಲಿಗೆ ಅವರು ಯಾರ್ಯಾರು ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅವರಿಗೆ ಅವಾಯ್ಡ್ ಸರ್ವಿಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಆರ್ ಯು ವಾಂಟ್ ಟು ಟೇಕ್ ಫ್ರೆಶ್ ಸ್ಟೆಪ್ಸ್, ಅವಾಯ್ಡ್ ನೋಟಿಸ್. ಅದ್ ಬಂದ ತಕ್ಷಣ ಯು ಕ್ಯಾನ್ ಮೂವ್ ದಟ್.
Avoid service, notice and avoid service in respect of 14. ಎರಡರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅದ್ರಲ್ಲಿ ಸ್ಪೆಲ್ಲಿಂಗ್ ಗಳೆಲ್ಲ ಇದ್ರಲ್ಲಿ ನೋಡ್ತೀವಿ ಗೊತ್ತಾಗಲ್ಲ ಇದು ದೇವಣ್ಣ
Serial number? Sorry. Yes. 2 weeks to comply the topic. Yes.
For matter, list number 1, serial number 1, Manjunatha for apparent.
In spite of the matter being posted before the register, the compliance of office objection for 5 times and appear for the appellant. Office objection has not been complied with. 16/1/2024, matter was posted before the court for compliance of office objection for 6th time and appear for the appellant in both the session. The office objection have not been complied with. Directed the registry to post this matter on top of the list for orders on 17/1/2024. On 17/1/2024, when the matter was called in the morning session, then appear for the appellant. Even in the afternoon session, there is no representation on behalf of the appellant directed the matters to be posted 18/1/2024 under the caption for dismissal. Today matter is posted for dismissal. Even when the matter is called in the morning session, none appear for the appellant. Afternoon session, no representation on behalf of the appellant. The office objection is not complied. It appears appellant is not interested in prosecuting this appeal. Dismiss for non-prosecution.
Raghu KK for appellant. Serial number 3.
Execution file ಆಗಿತ್ತು ನೋಡಿ ಇದು. So,
Suresha for appellant. Serial number 7.
Yes, execution pending ಇದೆ ಸರ್, ನೋಟಿಸ್ ಆಗಿದೆ 17ನೇ ತಾರೀಕು.
ಅಲ್ಲೂ ಅವರು ಜಡ್ಮೆಂಟ್ ಲೆಟರ್ಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
ನೋಟಿಸ್ ಪರ್ಪಸ್ ನೆಕ್ಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್.
ರಿಜಿಸ್ಟರ್ ಮುಂದೆ appear ಆಗಿರೋದು.
ಅರ್ಜೆಂಟ್
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು. None appear for the appellant. At the last chance, 2 weeks time is granted to comply the top sections.
ಇಲ್ಲ ಸರ್ ಅದು
None appear for the appellant. Last chance, 2 weeks time is granted to comply the top sections.
Serial number 13, N.V. Vasant for appellant. Serial number 13.
ವೆಬ್ಸೈಟ್ ಹಾಕಿಬೇಕು ಸರ್ ರಿವಿಷನ್ ಬೆಂಚ್ ಹಾಕಿ
ಎಜುಕೇಶನ್ ಹಾಕಿದಾರೆ ಇದರಲ್ಲಿ ಎಜುಕೇಶನ್ ಹಾಕಿದಾರೆ ಇದರಲ್ಲಿ
ನೋಡಿ ಸರ್
Six. So PK. Number 26, Kishore PK.
Couple of years. Couple of years, like before the cancel, sir. But you do not have a super. When the matter is called in morning session, appear for the appellant. In afternoon session, no representation. Behalf of the appellant, as a last chance, week's time is granted to compare the top sheet. Execution file. Experiment appear ಆಗಿದೆ ನೋಡಿ.
ಸಾರಿ ಪೋಸ್ಟ್ ಆಗಿದೆ ಸರ್. 4 ಸಾರಿ ಅಬ್ಸೆಂಟ್, 1 ಸಾರಿ ಮಾತ್ರ ಪ್ರೆಸೆಂಟ್. ಫಸ್ಟ್ ಟೈಮ್ 6 ಸಾರಿ ಪೋಸ್ಟ್ ಆಗಿದೆ. ಮಧ್ಯದಲ್ಲಿ 1 ಸಲ ಬಂದು 3rd ಟೈಮ್ ಪೋಸ್ಟ್ ಆದಾಗ ಬಂದು ಟೈಮ್ ಸಿಗುತ್ತೆ.
In spite of granting time for 4 times to comply that office objection before register, the office objection is not complied. Today it is posted before the court for non-compliance of the office objection for 5th time. Even today, when the matter is called morning session, none appear for the appellant. Afternoon session, when the matter is called, none appear for the appellant. Read this matter Monday at the top of the list for orders